started. Ricardo Johnson. Stand up, please. I reviewed the probable cause affidavit to find a factual basis. State.
Ricardo Johnson, Judge, he scores 19 points on the Dre. He is on probation with the department. He has open violations of probation pending. The department will.
Pardon me, Judge. The juvenile is being broadcasted.
I'm sorry?
The juvenile proceedings are being broadcasted right now.
Yes?
They can hear us in the jail.
All right, let me see if I can get this straightened out.
Good morning, Your Honor.
Who are you?
My name is Mark Astor, A-S-T-O-R. I'm here on behalf of Jessica Graves Bianco. She's a domestic case. She's the second one down on the court's docket, Your Honor.
Second one?
Yes. I actually haven't had a chance to meet with her, but I was retained to represent her.
I'm sorry, I didn't know you were, I
No,
saw
no.
you walk up, but I
No, it's okay, Your Honor.
didn't know if you were a movie star or what.
I'm working on it, but not so far, not so good.
All right, where is Jessica Graves Bianco?
I'm right here.
Oh, you are? Okay, where's that?
I'm right here.
Main jail, Your Honor.
Main jail, that clears it up. I'm right here. All right, I reviewed the PC affidavit.
I actually haven't seen it yet, Judge, although I'm somewhat familiar with the facts because I was retained by the husband, who's the alleged victim in the case, and he hired me to represent her, and he wants her out.
Is he here?
No, but I don't know if Madam, a victim advocate, has spoken to him, but I can put him on the phone if the court needs to hear from him. I can represent as an officer of the
Well,
court.
based on the PC affidavit, I find there's a factual basis. Now, you said based on your conversation with me, you can represent what?
That he wants her out, and additionally, he wants to have contact with her. What I can tell the court is that he's going to vacate the marital residence because there are 2 young children.
He is?
He wants to vacate the marital residence. He wants the mother back in the house to take care of the children. He says she's a good mom. And I think they need to have, he'd like to have contact with her because of the children. So we'll see if the court can not impose a no contact order, perhaps a no violent contact order. And if the court would consider releasing her OR, I don't believe there's a history of prior arrest or failures to appear, although.
Any history? Okay.
No, Your Honor, I did not see any history.
Have you talked to anybody?
Um,
Victim at all?
Your Honor, I left a voicemail. I did not actually speak. If you'd like for me to try it again, I'm glad to try.
He called me 5 minutes before we came before Judge.
I'm sorry, I didn't hear you.
He had called me 5 minutes before I came before the court. I'd be more than happy to make him available.
I can just try to reach him very quick right now.
I'm sorry.
She's going to try to reach him, Your Honor.
All right, well, let me call the previous case. She'll make that phone call. I'll call you back. Thank you. Selena Mays.
That's Maine, Your Honor.
Thank you. All right, I reviewed the probable cause affidavit. I find there is a factual basis. State recommendation on the bond.
Yes, Your Honor, there is significant prior history of batteries. Would you like me to give you prior history on the case?
Sample.
Most recently, Your Honor, in 2015, aggravated battery with a deadly weapon. He was arrested on 2015 assault arrest, in 2015 battery, false imprisonment, tampering, violation of domestic violence, arrest in 2016, possession of cocaine, resisting possession of drug paraphernalia, and in 2016, attempting to tamper with evidence, possession of cocaine, possession of heroins, introduce contraband
All right,
to a
what are you
facility. Your Honor, at this time, I would ask for at least a $25,000 bond.
Let me read this again.
And that would also be based on the injuries observed in the PC, Your Honor. And for the record, Jessica Butler on behalf of the state.
The injury was to who?
There were injuries to the victim, Your Honor. Extremely swollen right eye, eyelid.
The blood came from who?
I believe the blood may have come from the defendant because she was in self-defense.
Okay, so the victim is on top of the arrestee is on the top of the victim who's being punched. The victim at this point was in fear for her life and reached, this is on the bed, right?
Yes, Your Honor.
In fear for her life while being held down by the arrestee who was punching her, she reached under the bed, got a knife, and struck the defendant. Is that correct?
Yes, Your Honor.
The victim refused to speak to the law enforcement officers. So did the defendant. Also refused. He's got a bad history. Defense, anything you want to say?
Yes, Your Honor. Ms. Mays said that she could afford at most a $200 bond, so we'd be asking Your Honor if you would set a $2,000 bond on this case. She's not on probation and doesn't have any other. She does have a pending case. There is an address where she could live that the alleged victim does not live at, so there could be a no contact order in this case, Your Honor, and without being violated, she could be let out of jail. She's lived in Florida her whole life, currently on disability, and all of her family is in South Florida as well, Your Honor, so no reason for her to leave the area.
You asked for how much? 10,000? Is that what you said?
10,000 is fine, Your Honor.
Okay, I can't ignore her history, but given the facts as put down in the PC affidavit, it looks a little cloudy there. But again, I can't ignore the history. I'm going to set the bond at $5,000. No contact in any way, manner, shape, or form with the alleged victim. No phone calls, no letters, no contact by anybody else except your lawyer. Do you understand?
Yes.
Okay. Thank you.
Your Honor, we'd be requesting an order to take photos of the defendant's injuries.
Okay. Your colleague here is going to give me that order, and I'll sign it.
Thank you, Your Honor.
Thank you. What? I see you're working tandem again. That way I won't hear it? Okay.
I think we want to hear it.
Jessica Graves Bianco.
Maine, Your Honor.
I'll do this one and I'll call you.
That is mine.
Oh, that is my use.
That's the one we were.
Well, I knew that. Just kidding.
It's under, Your Honor.
All right, did we find out anything?
Yes, Your Honor, I do have Mr. Bianco on the phone right now, and he's indicating that he is not in fear. He is fine if Your Honor allows contact, and he did say that
Is he a speaker?
Is
Is he on speakerphone?
I can put him on speakerphone.
Yeah, I
if
just
you'd
want to
like.
hear him confirm everything.
Anthony, I'm going to put you on speakerphone so the judge can hear you, okay? Anthony, can you hear us?
Yes.
All right, what is your name, sir?
I guess, contact.
No, what is your name?
what's
The
his
judge
name?
is asking what is your name.
Oh, Anthony Bianco.
Okay. And you two, you and this lady live together?
Yes,
All right, you know the allegations of this matter, correct?
I do.
In fact, you gave the information to the police?
I did.
Okay. Has this ever happened before?
No, never.
Are you in fear of her?
No.
Do you have any
Not
reason
at
to
all.
believe this will happen again? Outside of the fact
No.
that it happened once?
Yeah.
Any reason for you to be, are you concerned that this may happen again?
No.
Do you want any kind of restraining order, any kind of restrictions? If I let her out, if she
No.
gets out?
No.
You want to live with
No.
her? Do you want to live with her?
Yes, I do.
You sure?
Yes.
Oh, I'm asking because you hesitated, that's all.
Yes. Yes.
What's the state looking for?
Your Honor, the state would ask for a $1,000 bond in this case and no victim contact.
Counsel?
Well, Judge, I'd ask to release Aurora. There's no reason to impose a bond. He wants to have contact with her, and as I've represented before the court, and you can confirm with the husband, he's going to vacate the marital residence so Miss Graves can be at home with the children.
So then a no contact order is fine.
No, I don't want to know contact. They
Well,
need
then-
to be able to have contact. He wants to have contact with her, and I would ask for an OR. There's no reason to impose a bond. It just slows everything up anyway.
Okay. You wanted to, does she have any history at all?
She does not have any history, Your Honor, just based on the facts of the case.
No.
Okay, I'm going to set the bond at $1,000, no harmful contact.
Okay, thank you,
You
Your Honor.
understand what that means, sir?
Oh, I'm sorry, I took it off speaker because the child. Anthony?
Oh, I'm sorry. I'm sorry.
Do you understand what I just said to the lady? I said no harmful contact. Do you understand? That means if she raises a hand at you, that would be a violation of the conditions of release. Do you understand that?
Understood. Yes.
Okay. Let me ask Jessica. Can you hear me? I hope so.
Yes, I can hear you.
You understand what I said?
Yes, I understand.
Any questions?
No,
Okay. Thank you.
thank you.
Okay, Anthony, so it's $1,000.
And Your Honor,
Sir.
just for the record, I would object to no harmful contact and ask for a no contact order, as it's,
And we'll call you.
I didn't ask for no contact.
no, I would say for the record, the state did ask for a no
Oh, yes.
contact order, and one would object to no harmful contact in lieu of a no.
I'm being somewhat familiar with how things work at Broward. Do I get paperwork here?
I don't know.
I do not. Okay. Okay, all right, Your Honor.
Oh,
thank
she'll get. Doesn't she get paperwork? She'll get the paperwork.
you. Okay, all right,
I
nice
hope
to meet you, Your Honor. Thank you for having me in the courtroom.
Thank you. What is your name again? I don't want to forget.
For the record, Mark, last name, with a K, last
You've been
name,
in front of me before, haven't you?
probably many years ago.
Yeah, well, I've been not a criminal for 4 or 5 years.
Yeah, and it's been a while since I was down in Broward, but
Well, okay, well, good to see you.
good to see you too, Your Honor.
If that's what somebody chooses, I can't, yeah, anybody can, okay. Okay.
This for me, Sam? Alicia Trusello.
That's no problem, Your Honor.
I couldn't hear that. Say it again.
North Broward, Your Honor.
Thank you.
Good morning.
I reviewed the probable cause affidavit. I find there's a factual basis. State.
State would ask for a $5,000 bond, Your Honor.
Go ahead.
Ma'am, are you currently employed?
Yes. I'm sorry, I can barely hear you. I'm sorry, I can't hear.
It's all right, not problem.
What type of bond would you be able to afford in this case?
None on my own, but I could find somebody, I suppose.
Okay, what about $3,000?
I can try to,
Okay. Your Honor,
I can try to get that up.
okay, ma'am, thank you. Your Honor, we would just respectfully request that the bond be set at $3,000.
State. Have you heard that any change of opinion? None? Okay.
No, Your Honor, and I do not see any ties to the community. It appears she's only been in Broward County. This is her first month in Broward County, so based on that, the state would ask the bond be set at $5,000.
What's her history?
I did not see any from Broward County, Your Honor. I don't know if pretrial has anything out of county, as
Do we know of anything?
she hasn't been resident here very long.
Has history out of the state of New Jersey, 2006 possession of drugs with intent, and 2007 possession of drugs was adjudicated.
Your Honor, based off of her lack of priors, we would respectfully request that the bond be set at $3,000.
1,000 it is.
Thank you, Your Honor.
No harm, no contact with the alleged victim in any way, manner, shape, or form. No phone calls, no letters. No one can contact this person on your behalf except your lawyer. Do you understand?
Yes, Your Honor.
Okay, thank you.
Your Honor, this time we invoke her right to remain silent.
You said something, I don't know what it was.
We invoke her right to remain silent, Your Honor.
Okay. Linda Augustin.
I'm just North Broward as well, Your Honor.
All right. Reviewed the PC affidavit. I find there's a factual basis. State.
Your Honor, state would ask for a $5,000 bond.
Your Honor, at this time, I'd like to make a probable cause objection.
What's that?
I'd be objecting to the finding of probable cause for battery here. It says that there were injuries, however, there were no pictures taken, there was no victim statement provided or mentioned of in this probable cause affidavit, and it doesn't even mention why they were dispatched. So respectfully, would be objecting to the finding of probable cause in this case.
And I have
Wait,
bruises
ma'am,
all
don't say
over.
anything about the facts of your case, please.
Yes, well, let me just, I don't know if I want to say. All right, well, I brought this up yesterday, so you would know this. What's the source of this information? No one's quoted, not the victim, not a witness. It just says somebody did A, B, C, and D. Is there any source for the information?
Well, Your Honor, the PC does identify the victim
I know that.
as Ian Lewis.
Well, as you saw in some of them I've read already today, the victim doesn't want to say anything. I don't know who told the police officer this. Do you?
Your Honor, it does not specify, but I think that, from the PC, we can prove the battery of intentional touch or strike against their will.
Well, then I guess well,
As-
that's not sufficient. I understand you may be able to prove something, but in terms of holding somebody on allegations from you presume to be the victim, but I don't know. What were you going to say now? You don't think this, except for what I just said, you don't think this is sufficient?
No, Your Honor, I believe that there are injuries that are mentioned in here, but there's no mentioning of pictures if they were provided and evidence or even
Pictures have to do with it. What if someone saw it and didn't have a camera?
Well, I understand that as well, Your Honor, but I'm just saying that there is no statement, there's nothing said that the victim mentioned this, we don't even know why they were dispatched. I don't know where the sources of the injuries are coming from.
Okay.
And Your Honor, if I could just be heard to follow up on that, injuries are not required as part of battery, and injuries are stated as observed, but certainly it's not required that there even be injuries or that photographs of those injuries be taken.
I believe that this is adequate. I'm just trying to decide about the source. I mean, I could pull out 90% of them at random, and it's going to say victim reported that, witness at the scene stated that, but here it just says the defendant did A, B, C, and D.
Yeah, that's true. I agree, but they still wrong for.
I hate who?
You said
It's me?
Because I don't think that's her.
Someone hates me. I mean, I'm not talking about this room.
Yeah.
We had an early day today.
Your Honor, the PC also includes details regarding their relationship, how long they've been dating, and are in a relationship together. I feel like that information.
Hey, let me read just the next one. Let me just read the next one.
Sure.
Unlisted time, officers responded to the available location in reference to the domestic disturbance. I met with the victim who stated. Let's look at the next one, okay? I mean, now it's clear. I mean, we all know that it was probably the victim that gave the information, but in the probable cause affidavit, it has to have certain requirements met. Here, battery. Let's see what this one says. I then knocked at the apartment such and such where I met with so and so. At the time, he was on the phone talking to someone and said to me, "Please come in." I then spoke with blank, who stated that blank. I mean, that's the way it should be done, and I think that most officers know that. And then if they get corrected one time, they definitely know to do it the next time. It's a waste of resources to have them come in, though. But I'm just a stickler for detail. 48 hours.
All right, thank you, Your Honor.
You have to have a source of the information.
Thank you, Your Honor.
You wanted, how much was the bond you wanted?
Your Honor, I had asked for a $5,000 bond.
And this was, she had a history, she's only been here a month or something like that?
Your Honor, it does show her month of residence as, her address is Palm Beach, so I do not have any history in Broward. I don't know if pretrial would have any other history for her.
$3,000 is the
Your Honor, if I
bond.
may inquire, please,
About,
about her ties to the community.
yes.
Sorry, Your Honor.
No, don't be sorry. Yes. is the
Ma'am,
answer.
are you currently employed?
I am a registered nurse.
Got
I'm a
her confused
healthcare
last time.
professional.
And how long have you been or how long have you been living in the state of Florida for?
My whole entire life.
And are you
I've never
current-
been to jail. I've never got in trouble before.
Okay,
Is
and are
that
you?
correct? Because I may be still talking about the last lady. I don't want to make any
I would
mistakes.
say I believe that we are talking about the last.
No, it's the same.
So
Yeah.
what is it? You don't
No.
have any history in this lady? Because I don't want to make any
I
mistakes.
don't have any
This is
history.
Miss Augustine,
I-
correct?
Sorry, ma'am. Hold on.
Miss Augustine?
Yes.
Yes,
Yes,
that's correct.
correct.
She's her address is coming up as West Palm Beach.
Any history?
Not from Broward that I can see. I don't know about outside of Broward.
Okay, Your
All right,
Honor.
what kind of bond do you want, counsel?
We were respectfully requesting, based upon the probable cause affidavit, the fact that Ms. Augustine is currently employed, she's missing work while she's in custody, based on the fact that there are no priors, and she's lived in Florida her whole life, she has no reason to leave. We would respectfully be requesting that Your Honor would ROR or set a $1,000 bond or consider pretrial release.
$1,000.
Would Your Honor consider releasing her pretrial, ROR to pretrial?
No, the allegations are serious. And I believe, I don't think the state's going to have any problem perfecting them. They just have to have a source for the information. I think $1,000 is pretty low.
Okay, thank you, Your Honor.
And Your Honor, I would ask for no contact with the victim.
I agree. No contact in any way, manner, shape, or form.
And at this time, we'll be invoking Ms. Augustine's right to remain silent.
I'm gonna perfect. Of course.
Ma'am, your bond has been set at $1,000.
There you go. This is for me to sign. Thank you. Linda Planton.
I guess $1,000. I don't know.
That's Maine, Your Honor.
Thank you. I reviewed the probable cause affidavit. I find there is a factual basis. Anything I should know, state?
Your Honor, she does have a battery from 2004 that she pled no contest, and in 2006 she had a battery arrest both in Broward County.
Asking for.
Your Honor, I would ask for a $6,500 bond.
I didn't hear you.
$6,500?
6,500. Interesting number. Go ahead. Depends.
Yes, Your Honor. At this time, there is no amount of bond that Ms. Planton can afford. She's not on probation. She doesn't have any open pending cases. Her history, as Your Honor heard, is an older. Cases are older, at least 10 years old. If she was released today, she could live with her mother in Miramar, where the alleged victim does not live, so they would be separate. She has been in Florida all of her life. She's a student. All of her family is in South Florida, and she does have 8 children that all live in South Florida as well, Your Honor.
And she's a student.
Yes, Your Honor.
8 children. I was reading this, 8 children in the last 14 years? Is that right?
Correct, Your Honor.
You realize you may have like 8 teenagers?
Yes.
Why you do? What you gotta? Come on. I mean, you gotta think about them too. I mean,
You're right.
how do you get yourself in these situations?
Well, I
don't know
found
what
out he
Look,
was
I don't know what
cheating.
happened. All I know is what's on this piece of paper.
Okay.
That
You
says
gotta-
do not talk about your case.
I'm not asking you anything about it. I'm just saying.
Okay.
I look at this and you gotta think about the kids. You
Right.
can't let yourself let this happen. I don't know what started it or anything, but having said that, $500 is the bond. No contact with the alleged victim in this matter. I mean, things. No calls, no letters. No one can speak to this person on your behalf except your lawyer. If you see him in church, you got to get up and leave. You understand?
Okay.
Nothing.
Correct.
Thank you, Your Honor.
Thank you. David Song.
Maine, Your Honor.
Mr. Song, I read the PC affidavit. I find there's a factual basis. State.
State would ask for a $10,000 bond.
I can't. You got to speak up.
I apologize, Your Honor. 10,000?
10,000.
Uh,
As opposed to 6,500 on the last.
no, wait, sorry, Your Honor. I apologize. I think I was looking at the wrong case. Is David Song?
David Song.
State would ask for 5,000.
Your Honor. Yes, Your Honor. Mr. Song indicated that the most that he could afford right now would be $300 or $400. So we'd be asking Your Honor if you would set the bond at $3,000. He's not on probation right now. Doesn't have any pending cases. To his knowledge, he does not have any priors as well. He's been in Florida for 10 months. He is gainfully employed, but he does not have any kids or family in South Florida besides the alleged victim.
Any history?
Your Honor, no history in Broward County.
You don't know of any other history?
I don't know of any history outside of Broward, Your Honor.
None?
No.
Yes.
No priors.
Yes? No. Yes. Correct. $2,500. The bond, no
Thank you, Your Honor.
contact with the victim in any way, manner, shape, or form. You were here when I spoke to the others and said that, right?
Yes.
You understand? No contact, no calls, no letters. The only person who can contact her, excuse me, is your lawyer. I'll give you 3 and see if you can do it. No. Thank you. I left civil to get out of this building. Okay, thank you. Song, where are you from, Mr. Song? Where are you from? It's Korean?
Yes.
I knew that.
Thank you.
Your cousin's Kim, right? Mr. Kim is your cousin? Most common name in Korea is Kim. That didn't go over that well. Anthony Martinez.
It's a reset, Your Honor.
It's a reset.
Stanley Benjamin.
Okay, so.
Maine.
Here, Mr. Benjamin, you got a domestic violence matter for which I find probable cause, and you have 3 felony probations of community control or violation. The first one, the misdemeanor, the domestic violence, $2,500 bond. The next 3 counts, 2, 3, and 4, each is a no bond hold. Thank you.
Thank you, Your Honor.
Addison Cheese.
Good morning, Your Honor. Good morning, Your Honor. North Broward, Your Honor.
North Broward? Oh, interesting outfits. What are the green green stripe outfits mean?
I don't know.
That's just what we have at North Broward.
Oh, okay.
General population.
All right.
Yeah.
I reviewed the probable cause affidavit. I find there is a factual basis. On count 2 is a probation community control violation. There's a no bond hold on that. And a $5,000 bond on the ag battery with the deadly weapon.
And just so Your Honor is aware, he does have 2 arrests for battery out of 2015, not including this aggravated battery that he has
Well,
violated.
in light
on.
of the no bond hold on a felony, I set it at $5,000. Thank you.
May I say something, Your Honor?
Yes, sir.
Sir, I would advise you, Marlise Mercado with the Public Defender's Office, I would advise you not to speak about the facts of your case. Everything you're saying is being recorded.
Yes, I know.
Okay.
I just wanted to say that the guy living with me, he was an alcoholic, and he was calling me names,
Okay,
and
sir,
I told
sir,
him not
please
to
don't
call.
say, I know, sir, please don't say anything else about the facts of your case, okay?
Anything else, sir?
They won't let me speak.
No one can stop you from speaking. You have the absolute right to speak, but I am telling you that their lawyer here is advising you not to speak, and I'm not going to advise you in any way. You can do what you want, but she is an attorney. She knows what she's talking about.
Yes.
I'll leave it at that. Did you want to say anything?
Fine. Yes, I did. I mean, I'm letting him stay at my house, and he's the one
Sir,
calling
everything
me
you're
the
saying
great
is being
names.
recorded, and this can be,
Yes, I
held
know.
against you. Okay,
Yes, I know.
All right, I'll let you speak. I'm just advising you not to speak, but you could go ahead if you would like.
All right, sir. You got the message, right, sir? Say
Yes.
whatever you want.
He was just calling me degrading names, and I was telling him not to. And because of my TBI, it triggered a relapse in me, and I got upset at him. I just told him not to do it. He kept on egging me on, and then he calls the cops on me, saying I stabbed him with a knife.
Okay, thank you,
That's
sir.
all I want to say.
Okay, thank you, sir.
And
You're
Your Honor, the
welcome.
state would ask for no victim contact.
How am I gonna no victim contact when when I'm letting him stay at my house?
Thank you.
Can't you kick him out of my house because he won't leave?
I have no idea about the relationship there, if you share the same place under a contract, if you both are under a lease agreement.
No, he's not under
No,
contract.
I'm not asking you. I don't want to, I'm not your lawyer. I don't know anything about it. But you are to have no contact with him. If you want to, when you get out, if you want to have him evicted, talk to a lawyer, whatever. But I'm telling you, you are to have no contact with him in any way, manner, shape, or form. No phone calls,
Okay.
no letters. No one except your lawyer can contact him on your behalf.
If I may, Your Honor.
That's fine.
If you need to address, Your Honor said, getting him evicted, or saying, make sure you go to the law enforcement officers. Do not go to the house by yourself.
Yes.
Do not go.
A violation of my order.
Yes.
Thank you, Your Honor.
Thank you. Thank you.
Have a nice day.
That was unusual. Usually it's a little later. All right, Matir Rivas.
Maine, Your Honor.
Where?
Maine.
Thank you. Mr. Rivas, I reviewed the PC affidavit and find it's a factual basis. I see there's a probation or community control violation. I don't know what that case number is. Is that 13? Is that a year?
It appears to be out of Dade County. It might be their case number, Your Honor.
Okay. Is it a felony?
It looked,
I'm sorry?
I can't tell from the booking sheet if it is a felony.
Let me see what we have here. Looks like domestic violence. Well, this is going back to 2012. There's a domestic violence by strangulation. I don't know how it was resolved. Wow, there's a lot of these things. Are these different cases or one case? I can't tell. Do you have these pages of a?
For Mr. Rivas, oh, in the back?
Yes.
Oh, oh, this looks like it might be his NCIC, okay. So it does look 2012 domestic battery by strangulation, and in 2012 kidnapping, false imprisonment. This would be the same 2012 case.
Well, I see arrest on
And-
June 29, 2013. I see another one
Yes, Your
March
Honor.
10th, 2012. They both are,
So there would be a 2013 false
Kidnapping,
imprisonment,
false,
battery, and kidnapping as well.
these are felonies. Another felony. What's the bond you're looking for?
Your Honor, the state would ask for $10,000.
Well, there's a no bond hold on the probation violation, and I give that great weight. I'm going to set the bond at $5,000. No contact in any way, manner, shape, or form, and a no bond hold on the probation violation. Thank you.
Thank you, Your Honor.
David Duback?
And Your Honor, for the record, Mr. Dubek's family is here.
Maine, Your Honor.
All right, what was the basis for aggravated battery?
Your Honor, I would say smacking her head onto the hard tile.
All right, I don't find probable cause on the aggravated battery.
Thank you, Your Honor.
No. That would not, as you described, be a basis for the harm. Well, anyway, it's not aggravated battery. I do find battery. So as the count, well, here's what I'm going to do. I found probable cause as to count 1. Probable cause as to count 3. And I'm finding no probable cause as to count 2. You want time to affect that?
Yes, Your Honor.
48 hours?
Yes, Your Honor. And the state would ask, as the third count, kidnapping is a punishable by life offense for a no bond on that count, pursuant to the.
Is there any history?
Your Honor, I don't see any history out of Broward County, but it would be pursuant to the administrative
We're not
order.
prepared to have
And Your Honor, at this time, defense will be objecting to a no bond hold. The state has not indicated that they'd be filing a motion pursuant to 3.132 or that they have.
Well, I think I can find,
Proof is
I
evi-
think I can do no bond, but I think the state has to go through an Arthur hearing.
That was my second point. They either have to file the motion pursuant to 3.132 or they have to prove that proof is evident, presumption is great, which Your Honor had indicated yesterday we were not doing.
Well, we're certainly not prepared to do that here.
I understand that, Your Honor, and so at this time we'd be objecting to a no bond hold.
Do you have your law book here? Let me see the,
And Your Honor, what I'm asking for is pursuant to the administrative order by Judge Weinstein that they be held no bond until they have an opportunity to have a bond set and an Arthur hearing in front of their division judge.
that's what I just brought up. I mean, I understand that. Let me look at this again more closely. Well, again, I look at it all closely. All right, defense, you want to be heard on the bond? In particular, count 3.
Yes, Your Honor. Mr. Duback indicated that at most he could afford would be a $1,500 bond, Your Honor. He's not on probation, doesn't have any open cases currently. He has a few misdemeanor priors, but no felony priors. He could live with his mother in Lady Lakes, Florida, if he was released. He's been in Florida for 20 years. He is gainfully employed currently. Does have family in South Florida as well as 2 children in South Florida, so no reason to leave the area at all, Your Honor.
And Your Honor, I'm just citing the current administrative order.
How did she get out of there?
For the kidnapping charge, is that what you're referring to? Well, Your Honor, I would argue that, he placed her in there. She was unconscious at the time.
To his place. He took her to his place, right? But
Why she was unconscious?
Well, I understand, but what happened afterwards that she ended up, Holy Cross? Did she call the police? Did he call the police? I don't know. You gonna tell me? I mean, that's a factor I can consider.
Your Honor, if you would like that information to be included about how she was able to, I guess, get out, or it sounds like the police found her on the couch. I don't know if she was even able to get out or if she was just able to call 911.
The police, I assume, had information that brought them there.
And I understand, Your Honor, if you would allow me 48 hours to perfect for that information, I would just ask that you not send a bond until that 48 hours so I can provide that information to Your Honor.
And, Your Honor, at this time, the Florida Rules of Criminal Procedure 3.132, it sets forth the procedure for pretrial detention pursuant to Statute 907.041. The state does have to file a motion if they are requesting pretrial detention and no bond hold. The state has not done this at this time, and in the latter, they have also not proved. Proof is evident, presumption is great, so the defense would be objecting to a no bond hold in this count.
And Your Honor, the basis of this, like I said, is not the Arthur hearing, but rather the administrative order in our county saying a judge at first appearance shall only make a probable cause determination for an arrestee charged with a punishable by life offense. If the judge finds probable cause, the arrestee shall be ordered held without bond. The arrestee wishes to give a bond, he or she must...
Wait. You're telling me that if I find probable cause, he shall be held without bond?
Yes, Your Honor, until the matter can be set in front of the division judge.
Can I see that, please?
And Your Honor,
I can give you, let me look for the actual administrative order. This is in my information, but I know
I can't understand how another judge can tell me what to do.
Well, and Your Honor,
sorry.
Trying
to make a record here. Under these circumstances.
And Your Honor, if I
No
may...
one knows more about the case in terms of judges than the judge, the magistrate hearing it.
And I understand that, Your Honor. I believe that the order is based on the fact that they would then see their division judge, and the division judge would then make that determination at that point, or an Arthur hearing would be held.
Can I see the rule?
And Your Honor, if I may?
Yes.
And pursuant to the Florida Rule of Criminal Procedure 3.132, as I do indicate, if the state is requesting pretrial detention, they do have to file a motion to seek that, and the state at this time has not done that. And so if Your Honor would like to give them time to do that, they could do that when they also perfect the probable cause affidavit, but until then, we would respectfully be requesting that Your Honor set a bond in this case and objecting to a no bond hold at this time.
It says here that the defendant advised she became unconscious during the beating and strangulation and does not know how she was removed from her home and brought to the defendant's home, where police found her asleep on the couch. She has no recollection of that portion of the incident. So there's nothing, there's nothing in here saying that she called the police. I don't know what's going on here, but it's obviously very, very serious charges. In particular, I find this pretty... The victim provided a sworn statement and agreed to prosecute signing a victim affidavit. Victim was transported to Holy Cross due to her severe contusions, lumps on head, and back pain. She was admitted to the ICU unit due to a brain bleed. The victim is currently stable, but it is unknown if there will be any permanent brain damage at this time. I mean, Anything else? Hey, anything else?
No, Your Honor, I'm looking for where it's
Setting the bond at
specific.
$250,000. Thank you.
Your Honor,
On that count.
And that would be over the state's objection, Your Honor, in regards to the administrative hearing.
Thank you. I don't mean fine in a facetious way. I mean, I understand.
That's on count 3, Judge.
Yes, count 3, $250,000. Count 2, just a third-degree felony? I don't know.
Count 2 is a
This was-
second-degree felony, Your Honor.
I didn't say 2. I said count 1.
Oh, it's a third-degree felony, Your Honor.
$10,000 on that one.
And I would like,
And
ask for no.
on the, I'm going to, well, given what I've read here, I can see aggravated battery. Another $100,000 on that one. If perchance he should get out in the next, before he sees the judge in this matter, there's no contact in any way, manner, shape, or form, I'm going to put him on pre-trial release conditions, 24 hours a day with a monitor, GPS monitor. Anything else?
thank you, Your Honor.
Did pretrial
No, Your Honor.
consult that?
Your Honor,
Thank
level
you.
1?
I'm sorry?
Level 1 control?
Yes, the highest. Thank you. Jeffrey Inoa.
That's no problem, Your Honor.
Mr. Inoa, I read the probable cause affidavit. I find probable cause.
Your Honor, if I may?
I want to hear what the state's position is.
Okay.
Oh, you're objecting to what I
Yes.
found?
Yes,
Okay,
Your
go
Honor.
ahead, make your record.
Your Honor, if I may make an objection to the finding of probable cause in regards to count 1, I would argue that per statute, there is no evidence of great bodily harm to the child, of permanent disability to the child, or permanent disfigurement to the child. It does say that the child did see the incident. However, I would still argue that is not great bodily harm, permanent disability, or permanent disfigurement, that this would amount to child neglect, if anything.
What's the child's, well, we don't have her name.
The name of the children, Your Honor? It is on,
I don't know if we want to say that on record.
we don't want to save it, but it is on the second page of the probable cause affidavit.
Starting with R. Oh, wait, well, which one? Count 2 is, this is confusing here. Count number 111. So I'm trying to figure out which one we're talking about. Where is the child neglect with great bodily harm? Where's the description of that?
Your Honor, I believe it's just a Scrivener's error. It appears to be under count 2.
All right, let me read it again. I agree with the defense. Really not much to say about that.
Would Your Honor allow for 40 hours per effect? I would argue that they're witnessing these incident as well as the situation with count 3 with the firearm would be neglect of a child with great bodily harm. And I would ask for 48 hours to perfect that count. If Your Honor is not in agreement with
Possibility
me.
of them suffering in the future, having seen this, is great bodily harm. I don't sure I understand. I'm not saying that. If you're reading into that, I have a lousy poker face.
Well, Your Honor, the discharging of the firearm in their presence as well, if you see count 3 that he discharged the firearm, I believe that that is child neglect with great bodily harm.
Per the statute, great bodily harm is defined, and in the statute, it requires great bodily harm, permanent disability, or permanent disfigurement, which defense counsel's state.
She's saying the
position.
mental aspect of it would be the permanent disability.
I
don't
understand.
know that that's an interesting argument.
Your Honor, I think the PC is there with the count.
All right, what I'm gonna do is, let me get back to this front page here.
I would simply object and say that this is child
Let's
neglect at its
count,
finest.
one.
Yes, Your Honor.
I'm gonna find no PC in that one, leave it to you, because I don't know the answer, and it's gonna end up being in front of the next judge to hear this, or the judge that has the case.
And Your Honor, if I may, I'm looking at the statute which defines child abuse, and under subsection B1, it says intentional infliction of physical or mental injury upon the child. And that's under the same statute, Florida Statute 827.03. So I believe that the PC is sufficient for mental injury.
And Your Honor, if I may, the statute is very specific when it says bodily harm, neglect child with great bodily harm, and it defines that it must be great bodily harm, permanent disability, or permanent disfigurement. And I believe that
didn't the state just read mental?
Well, she read the definition of abuse, not the definition of great bodily harm.
And also, but this is negligent.
Defense's position is that if Your Honor would like to find probable cause in neglect of a child negligence, we could see that, Your Honor, but not neglect of a
All right,
child
look,
with great bodily harm.
I'm not sure on this one.
And Your Honor, the statute reads abuse, aggravated abuse, and neglect of a child under that same statute.
Yes, I thought that was important, because you read before, I heard the word intent, but this is negligent. Look, it says negligent child with great bodily harm. How is it styled, the statute?
It is, the statute reads abuse, aggravated abuse, and neglect of a child, and then on the bookie sheet it says neglect of a child. And if Your Honor would like me to provide you with the definition of neglect of a child, it means under subsection E1, a caregiver's failure or omission to provide a child with care, supervision, and services necessary to maintain a child's physical and mental health.
Right. I'll give the defense the last word.
Your Honor, we understand that this could be possibly neglect of a child. We're not disagreeing with that. We are disagreeing with the great bodily harm aspect, which the state has not provided a definition for. And per the statute, it needs to have great bodily harm, permanent disability, or permanent disfigurement. It is not the definition of abuse. It's the definition of great bodily harm. And so at this time, we respectfully be objecting to a finding of probable cause for count 1, Your Honor.
No, when I have a moot court, third-year law students at some law school I get invited again, I'll recommend this as the question.
Could be a good one, actually.
Well, why else would I do it?
And Your Honor, why great bodily harm is what it appears on the booking sheet under this statute, it could be, under
All right.
child
All
neglect.
right, I got to make a decision. I'm going to go with the state on this one. You're going to have to make your arguments in front of the judge, that's all. All right. Now, what the recommendations in terms of bond?
Your Honor, I would ask for $10,000 on each count.
Your Honor, if I may inquire.
Yes.
Sir, is Marlise Mercado with the Public Defender's Office? Are you currently employed?
No.
No? Do you have family here in Florida?
No, I work, yeah.
Okay, and do you have family here in Florida?
Yeah.
And do you have a place that you could go stay at that's not with the children?
Yeah, my mom, my brother, but.
Okay, and how long have you lived in Florida for?
I came to Florida to 2007.
2007? Okay, thank you. Your Honor, defense would respectfully request that the bond be set at $7,000 for count 1 and $5,000 for count 2 and $5,000 for count 3. He is employed and he has been living in Florida. He has ties to the community. He does have children here, and he has stated though that he could find a place to stay without them there while they do figure this out.
All right, I agree with the state. Again, $10,000 in each count. No contact in any way, manner, shape, or form.
And Your Honor, I would ask for no contact with the victim as well as the child victims.
Your Honor, defense would be objecting to that. That is something that the dependency court can handle at this time. On the dependency orders that he isn't allowed to have contact with the children, or they so find that he shouldn't have the shelter hearing, we believe that is a matter that should be addressed in family court.
And I think that they did
Well,
address it.
How did you describe the shooting? It said he went out on the balcony and shot into the parking lot. Is that right?
Yes, Your Honor,
Yes.
shot up in the air, I believe.
And then we walked back in, his wife said, if you didn't go out last night, this wouldn't be happening. This is a pretty bizarre thing. But I worry about, I mean, he has no history?
Your Honor, he has no history that I could see from Broward County. I don't
All
know.
right, well, see, there's no bright spot here for him. Even with no history, the aberration is so extreme that it worries the court. And I'm only going on what's before me, and unless there's other facts brought in, I mean, this is serious.
I understand, Your Honor, but I believe this case was here. in front
I
of me
will
already.
allow a supervised contact with the children. Now, by supervised, I mean, I'll leave that to the judge in this matter to make that final determination, because I'm not going to do that. I don't know the family, I don't know anything.
Okay, so just no ruling in regards to the children, but no contact with the victim, the adult victim?
Your Honor, this
If I
ma-
say supervised, I got to define that.
Yeah, and I believe, Your Honor, that the shelter hearing did address this and asked that he be removed from the shelter and asked for no contact. So it's already really been addressed with the,
Well, and Your Honor, if I may, this goes
Shelter
with
hearing.
defense's position. This case was here in front of Your Honor this morning about it. It is a family court matter. Family court can deal with what's going on with the children there. Your Honor was willing to leave it open to the next judge, so I
Well,
respectfully
again, going
request.
back to what I said, this is, it's just a shame that he has no history,
well,
And
Your
yet-
Honor, I would ask pretrial to look outside of Broward.
okay?
He has no priors, Your Honor.
None. This is such an extreme situation. What he did allegedly is huge.
I understand that, Your Honor. With that being said, the dependency court is looking into that themselves, and if they make their own
Did
finding.
you already say that they made a determination there'd be no contact? State?
Your Honor, I believe that is what happened in this.
It's been reset for this Monday because he wasn't present. He's in custody.
All right, then what I'm gonna do is, I'm not gonna allow any contact until there's a final determination by, what's the name of the agency?
DCF, Your Honor?
DCF?
DCF? Okay.
So is this, the
No contact with the kids or the mother,
with the children until a determination is made through DCF?
or the subsequent judge, the judge who has the case,
Okay, thank you, Your Honor.
until further order of the court, or, look, if DCF makes a finding, doesn't there have to be an order entered by a judge?
The only thing that's worrying me is that I don't want DCF to make the finding on Monday and then, this order still be in place in criminal court. That's my concern. I would respectfully request that this be left in family court. That way, if DCF makes the finding on Monday, then the finding stands.
Does the DCF make a finding of no contact? Does that have to be signed off by a judge?
Yes, but it's a family court judge, Your Honor.
All right, so, but still, I mean,
But it doesn't mean that the criminal will not be lifted until it goes in front of a criminal judge, Your Honor.
can the criminal court judge overrule DCF? Yes.
I do not believe so, Your Honor.
I don't know the answer to that question.
You said that's not a family court?
Yes, Your Honor.
Doesn't the family court, this is too much for a simple guy like me.
I mean, it's up on Monday, Your Honor. I would just respectfully request that you leave the no children contact order up to DCF to handle on Monday, Your Honor. And then if not, the judge presiding over this case can then later order it if DCF does not. But I do believe that if DCF allows contact, then the later judge would not prohibit it.
All right, I'm not gonna allow contact until there's a further court order entered, whether it be the family court or the criminal court. But until there's an investigation by the DCF and there's a finding by a judge, after that, I'm not allowing any contact with the kids or the mother. Thank you.
Your Honor, if we could go back on Mr. David Duback real quick.
All right, I'm just writing something down, just a minute. David who?
David Duback, the defendant that was up just before Mr. Reyes.
Yes.
I just want to let the court know that the defendant is exercising his right to remain silent at this time.
Okay, fine. Make sure everybody there knows it.
Yes, Your Honor.
Andy Santos.
Maine, Your Honor, and he also needs a Spanish interpreter.
Presta atención que el intérprete va a estar ahí.
Mr. Santos, I reviewed the probable cause affidavit. I find there's a factual basis.
Señor Santos, declaro que hay fundamento para el cargo.
State.
Your Honor, the state would be asking for a $10,000 bond based on the facts of the case.
El Estado está pidiendo una fianza de $10,000 según los hechos del caso.
I have not seen any prior history out of Broward County. However, Your Honor, I'd ask pretrial to look as he's only been a resident for 4 months. And if Your Honor would be, if he is able to be on pretrial release, I would ask for a GPS monitor.
No tiene antecedentes penales en Broward, aunque solamente tiene 4 meses viviendo aquí en Fort Lauderdale. Si le...
Por favor, sí. Could you speak up, please? He's having trouble hearing.
Okay. Están pidiendo, el Estado está pidiendo una fianza de $10,000. No tiene antecedentes penales, aunque solamente lleva 4 meses viviendo aquí en el Estado o en Broward. Y si su señoría lo deja salir con ciertas condiciones, pido que le pongan un monitoreo electrónico. Un momento, no conteste.
Pretrial release. Did you have anything to say?
No priors, Your Honor.
No tiene ninguna condena anterior.
Well, this is also an extraordinary one.
Este es un caso también bastante especial.
State wanted 10,000.
Yes, Your Honor.
Defense. Defense, what do you say?
La defensa que contesta.
One moment to inquire, Your Honor.
Yes.
¿Cuánto puede pagar?
Your Honor, he does live in Florida. He does have considerable family in Florida as well. He is currently gainfully employed. Cannot afford the $10,000 bond. Your Honor, he said that he would only be able to afford a couple $100, so we'd be asking Your Honor to set the bond at $2,000.
Anything else? I'm setting the bond at $7,500. I want on pretrial release conditions, level 1, GPS, no contact in any way, manner, shape, or form with the alleged victim in this matter.
Voy a imponer una fianza de $7,500. No puede tener contacto de ningún tipo con la víctima y va a tener un monitor electrónico con GPS.
And Your Honor, I'm sorry, I missed the bond amount.
Sorry?
How much was the bond amount?
$7,500.
Perdón, la fianza fue de $7,500.
Thank you.
And that pre-trial, Judge?
Yes. Ket Estache.
Paul Ryan, Your Honor.
Yes.
I reviewed the PCF data to find there's a factual basis. State recommendation.
State would ask for a $5,000 bond.
Your Honor, if I may inquire.
Yes.
Ma'am, are you currently employed?
Yes.
Yes. And how long have you lived in Florida for?
Over 10 years.
Over 10 years. And do you have family here?
Yes.
And
Oh, yes.
what type of bond would you be able to afford?
What, I'm sorry?
What type of bond amount would you be able to afford?
1,000.
Your Honor, defense respectfully requests that the bond be set at $3,000. She is employed.
How much you said?
$3,000, Your Honor. She is currently employed and she has been living here for over 10 years.
You see, the victim stated he was not in fear for his life at the time and refused to give a recorded statement. All this information came from her? Am I reading that right? According to the defendant.
Yes, this sounds like this last information.
I mean, it's pretty amazing. All this information is given, and then about the knife and the drinking and the bottle, and then the officer stopped the defendant and read her Miranda rights. All right. Anything else? You said how much, counsel?
$3,000, Your Honor, or $1,000, Your Honor, respectfully.
Oh, my. Do I hear $200?
$1,000, yes.
3,000 or 1,000?
We would request $1,000, Your
The
Honor.
comedian. $2,500 is the bond. No contact with in any way, manner, shape, or form with the alleged victim in this matter. It's no letters, no phone calls, no visits, no nothing. If you see that person in church or at a restaurant, get up and leave.
Okay, but I have a question.
What's that?
I have a question.
Don't
Yes,
say
sir.
anything
Yes.
about the facts of your case, ma'am.
Go ahead. What's your question?
I'm paying rent in the house. So if I leave the house, who gonna pay the rent?
I'm sorry?
You rent the house?
Yeah, but I pay the rent. He don't pay no rent. So if I leave the house, who is gonna pay the
Well,
rent?
I'm not your lawyer, and your lawyer will
Okay.
explain things to you, but in general, if you're on the contract for renting the house, you can have him evicted, I would think, but I don't know the facts. I don't even know if I
Alright.
should have said that. Talk to your lawyer, okay?
And make sure you call law enforcement before you go back there if he's there.
Okay,
Thank you.
no problem.
And at this time, we're invoking Mr. Stash's right to remain silent.
Maria Mejia.
That's North Broward, Your Honor. Maria is going to need the use of the Spanish interpreter, please.
Thank you, sir. Ms. Mejia, I've reviewed the probable cause in this matter, and there's two outstanding misdemeanor warrants.
Señora Mejía, revisé el caso y hay 2 casos pendientes de su arresto.
And that, in and of itself, is sufficient for you to be held
Y eso por sí mismo es suficiente para que la puedan detener
with a bond
con una fianza
pending resolution of those matters.
hasta que se resuelvan estos 2 casos.
Do you want to resolve them today?
Señora, ¿usted quiere resolver sus 2 casos el día de hoy?
Sí.
Yes.
Do you know what the charge? Well, one's a traffic ticket.
Uno es una infracción de tráfico,
State, and the other one says misdemeanor. Can you tell me what's going
el
on?
otro dice un delito menor. Un momento, no conteste.
One's a trespass, Your Honor, and one's an obstruction.
Una es intrusión y la otra es obstrucción.
One's a trespass and one's what?
A pedestrian obstruction, the traffic, maybe panhandling, Your Honor.
Yes, Your Honor.
Una es obstrucción de tráfico, tal vez estaba usted vendiendo algo. No conteste.
State, you want to resolve this?
Your Honor, the state would offer to resolve both cases in adjudication and credit for time served.
Adjudication credit for time served.
El Estado está dispuesto a resolver los 2 casos, le van a declarar que hay un fallo y darle tiempo cumplido.
Yeah, if she wants to resolve, that would be the
Señora,
offer.
¿está usted de acuerdo con lo que le están ofreciendo para resolver su caso?
I didn't hear what you said.
I said if she wanted to resolve, that would be the state's offer.
I thought you said something about $1,000.
Es que ya está grave.
¿Perdón?
Yo he estado grave, le digo enferma, yo estoy enferma.
I'm sick, I'm very ill.
Well, are you taking any medication?
¿Está usted tomando alguna medicina, señora?
Sí, mija.
Yes.
I can't take a plea if she's on any medication. It's affecting her. Let me ask questions. What medication, are you taking medication in the jail?
Señora, ¿está usted tomando medicinas ahí en la cárcel?
Medicina no me han dado, pero me han estado tratando el azúcar y la presión.
I haven't received any medicines, but they have treated my sugar and my blood pressure.
Have you taken medication for your sugar and blood pressure?
¿Ha tomado medicinas para el azúcar y la presión?
Aquí no.
Not here.
Pero en mi casa sí.
But back at home, yes.
So she's not taking her medication.
Entonces aquí no ha tomado ninguna medicina.
No.
No.
Do you take any other medications?
¿Toma usted alguna otra medicina?
Solo para el azúcar.
Just for the sugar.
Are you diabetic?
¿Es usted diabética, señora?
Sí.
Yes.
Is it, do you understand everything I'm saying?
Señora, ¿usted está entendiendo todo lo que el juez está diciendo?
Sí.
Yes.
Is this medication that you're not taking, is it affecting your ability to understand anything?
¿Esta medicina que usted no ha tomado le afecta su habilidad para entender las cosas que estamos diciendo aquí?
Bueno, yo entiendo todo lo que me están diciendo.
Well, I'm understanding everything you're saying.
Okay. Do you want to resolve these matters?
Señora, ¿usted quiere resolver estos dos casos que usted tiene?
Sí, claro, porque yo estoy enferma.
Yes, of course, because I'm sick.
How long have you been in jail?
¿Cuánto tiempo tiene usted ya en la cárcel?
Ayer me trajeron.
They brought me in yesterday.
The offer is what we call an adjudication.
Lo que le están ofreciendo es lo que llaman, hay un fallo y le dan tiempo cumplido o tiempo servido.
That means that you'd be adjudicated guilty of these two charges.
Quiere decir que la van a hallar culpable
It would be time
de
served.
estos dos cargos. Su sentencia ya es solamente el tiempo que lleva ahí en la cárcel.
There would be some costs imposed, but
Tendría
you would
que-
be released today.
Tendría que pagar algunos gastos, algunos costos, pero la van a dejar salir el día de hoy.
Ay, pero yo no tengo dinero, mija.
Oh, but I have no money.
Your
Si
Honor
yo
can
no he
give her time to
trabajado.
pay.
What's that?
Your Honor could give her time to pay the court costs.
I can do what for who?
You could, if she needs time to pay, you could give her 6 months or a year to pay the
El
court
juez le
costs. if
podría
that's
dar
what she
tiempo
needs.
para que usted pueda pagar esos gastos.
I don't even know what costs are.
Un momento.
Yes.
There may be, well, whatever the costs are, you would have, I'd give you a year to pay it. I don't know if they'd be eager to come for it or not, but that, I would give you a year.
Yo le podría dar hasta un año para que usted pueda pagar esos gastos. No sé si se los van a cobrar, pero tendría hasta un año para pagarlos.
Qué bien.
¿Perdón? Señora, ¿qué dijo?
Do you object to a withholding waive?
No, Your Honor.
All right, here's what it is. I'm gonna get rid of the money issue.
Señora, no se preocupe, no le van a cobrar este dinero.
It's gonna be you wanna do this, correct?
Usted sí quiere resolver su caso, ¿verdad?
Your Honor,
Sí.
Yes.
Your Honor, if I may, just ask if she's on probation.
She's on probation. This is,
Well, I just want to advise her. I don't,
this looks like no show. Are you on probation for anything?
Señora, ¿está usted en probatoria o libertad supervisada por algún otro caso? Señora, ¿está usted en probatoria o en libertad supervisada por algún otro caso?
No.
No.
You want to try to hang in and see the judge?
Okay. Any reason why I can't post sense at this time? State defense?
No, Your Honor.
Withholding waive. You'll be released today. Thank you.
Señora, le van a dejar salir hoy mismo. No se preocupe, gracias.
Your Honor, Deputy Garrett, North Broward. Can we pull somebody out of turn? I got to send them back. He's sick. We got to take him back to the infirmary.
Yes, sir.
He's going to be on reset for tomorrow. I think it's Cohen. Let me see his card.
Yeah, Peter Cohen.
Cohen?
Peter Cohen.
What's the charge?
Okay, Senor.
What's the charge?
Okay.
I don't have it on that.
Mary, what's his charge? Cohen, come out.
Does anyone know what page it is in our docket?
I got it on page 18 on our docket over here. Peter Cohen's got 3 counts. Driving while license suspended, failed to wear a safety belt, and improper change of lanes.
Okay, where's Mr. Cohen?
He's coming right now. He's walking very slowly, but he's coming.
Defense has no probable cause objections, Your Honor.
I'm sorry?
I have no probable cause objections, Your Honor.
You have none. Okay.
That's a first.
All right, Mr. Cohen.
Yes, Your Honor.
Let me take a look at this. I haven't seen this one yet.
Thank you, Your Honor.
Good. 15 aliases. Wow. That could be a record for me. You cut off a police officer, it says here. Wow.
Yes, sir.
No, don't say anything. Just listen.
Sir, I advise you not to speak about the facts of your case.
Well, I didn't take that as an admission.
Don't matter to me because I won't be here still.
Oh. All right.
It's a felony, so.
Okay, I reviewed the PCF today. I found a factual basis as to each count. The bond on count 1 is $750. I'm going to ROR you on count 2 and ROR you on count 3. Anything else?
Your Honor, if I may.
You may.
Sir, are you currently employed?
Yes, ma'am.
And how long have you lived in Florida for?
About 20, 25 years.
And do you have a place to go if you were to bond out?
Yes, ma'am.
Where are you gonna go live?
Yes, I have an address where I live at. I have a job I've had for 4 years.
Okay, thank you. And do you have family here?
No family here.
No family here?
Suspended license, 5 years suspension on his license. $750 is the bond.
Is Your Honor consider pushing at 600?
No.
Thank you, Your Honor.
Patricia Parker. Sorry?
Parker bonded out this morning, Your Honor.
Thank you. Ginger Cross.
Pour on, Your Honor.
All right. I read the PC affidavit. You have 2 outstanding traffic matters that were, I guess, failed to appear. The first one, the bond is at $2,000. The second one's at $750. Do we know what these are? Driving on a suspended license. Driving without a driver's license and driving on a suspended license. State, just leave the bonds where they are.
Yes, Your Honor. I just ask that the bonds remain where they are.
Okay. Defense,
May I inquire, Your Honor?
quickly.
Ma'am, are you currently employed?
Yes.
And do you have family here in Florida?
Yes.
And how long have you lived in Florida for?
5 years.
5 years?
Your Honor, we respectfully request that the bond be set at 500 in count 1 and 500 in count 2. She is currently employed. She does have family here, and she has lived in Florida for an extensive amount of time.
Which one's count 2? Not having a license? Do we know?
Yes, Your Honor. Or just that her ability to drive in Florida is not valid.
All right. I'm gonna leave count 1 where it is. Count 2, I'll lower to $250.
Thank you, Your Honor. This time we're invoking Ms. Cross's right to remain silent.
All right. Oh, I didn't sign this? No, Judge. Okay, no, it's 1. Catherine Ellis.
Look, that's no crowd, Your Honor.
I'm sorry, North Broward. Thank you. Ms. Ellis, I reviewed the probable cause affidavit. I find there is a factual basis.
Your Honor, if I may.
Just a minute. There was a reason to put a big star next to this. Ah, yes. What does this mean? I'm not asking you, I'm asking the lawyers. Sexy BBW 420 plus fun plus more. What's the first? Sexy, I know what that means. What's 420 mean?
I don't know, Your Honor.
Your Honor, I believe it is a marijuana friendly.
That 420 mean?
Yes, Your
Okay.
Honor. I believe. I'm not sure if that's
Oh,
what
well,
they
I
were
mean,
doing here.
you meet a lot of people in your line of work, I understand. So do I, but I didn't know what 420 meant. All right, you want to, what?
I'd like to make a probable cause objection, Your Honor, to count 1 and count 2. I believe that the probable cause affidavit does not show evidence that Ms. Ellis was present during the robbery and/or during the Berg dwelling of the structure and conveyance. If the state wants to charge her with conspiracy to commit robbery, firearm, and burglary, I could understand that. Or if they wanted to charge her as an accessory before or after the fact, I could understand that. But from the probable cause affidavit, it doesn't say that Ms. Ellis was present when the actual robbery occurred or when the car was broken into. It just says that she was present prior to.
And Your Honor, I would argue that she, through principal theory, she is, the person who brought the victim here. She coordinated everything.
I agree with the state. Make a recommendation on the bond.
Your Honor, and I wanted to provide you with a copy of the administrative order. This is a first-degree punishable by life felony. Now, this is not the full administrative order. It's 270 pages, but it does say for first-degree punishable by life felonies that the case should be set for no bond. And then if you read further on in the order, I do not have the specific page in front of me, but my understanding is that the division judge would be assigning the bond in these cases. The state would ask for no bond due to this administrative order from Judge Wine.
Where are you reading this from? Is for section what?
If
What
you-
page are you reading it?
Your Honor, it is this administrative order establishing a bond schedule, and on page 3, if you'll see first degree life felony, the bond amount is to be set at no bond. And robbery with a firearm is a first degree life felony, Your Honor.
And Your Honor, if I may.
Yes.
Once again, the defense would be objecting to the state requesting no bond on this. Pursuant to Florida Rules of Criminal Procedure 3.132, it states that they must file a motion for pretrial detention, or they must prove that proof is evident, presumption is great. The state has not done the latter, nor have they provided us with a motion requesting pretrial detention, and that is pursuant to Florida Rules of Criminal Procedure 3.132. So if the state would like to have time to provide us with that motion, they can, but until then, we would be objecting to a no bond hold in accordance to Florida Rule of Criminal Procedure 3.132.
And Your Honor, reading the first section of that administrative order on the Florida Rules of Judicial...
First section, where's that?
The first page under Section A, Florida Rules of Judicial Administration 2.215B3, the Chief Judge shall develop an administrative plan for the efficient and proper administration of all courts within that circuit. That is
I'm going to tell you, I'm quite frank with you. I do not believe that efficient and proper administration can ignore justice. I'm being that profound. The rules are perfectly clear. The statutory framework within the criminal law, criminal procedure, criminal laws are quite clear. To say that under all circumstances, if you're charged with a first-degree life felony, in all circumstances, it's a no bond hold. I don't believe that anybody can tell me that I have to follow that.
Well, Your Honor, that is per our Chief Judge Weinstein. In addition, it does not mean that she will always remain on a no bond hold. She will have the opportunity to have a hearing date immediately with her division judge, where that division judge will set what bond they feel would be appropriate given everything in the case.
I think we had this on a previous one. The fellow I gave what $250,000 bond or something like that.
Your Honor, if we
I had a question.
Okay.
You remember that? We had that, right?
Yes.
And we discussed this. I disagree. And I'll do what I deem appropriate, and I think that's what every judge is supposed to do. I don't think that anybody is, when you sentence somebody, you get in trouble if you treat everybody the same. You don't look at them as individuals. You don't look at the facts of the case. And proof evident I don't even like saying the words presumption great. I don't even know what it means. Proof evident is higher than reasonable doubt. And under these circumstances, if I've done something wrong,
Your Honor, I
take
would
it
just,
to a higher circuit, a higher court.
Your Honor, if I may be heard.
No, I've ruled.
Okay, Your Honor. Thank you, Your Honor.
Don't talk me out of it.
and my
Actually,
only
I
request,
will.
could we put it on a brief recall? If I could provide you with more information regarding the administrative order, would you reconsider that?
I'll recall it if you want.
I just would like to talk to, I'm going to ask Mr. Linder, who does the magistrate, during the week, and see if he has
Oh, Scott
law
Rath,
that he
and I
can
know each other quite well.
present.
If also, if
No,
the
he'd probably
state,
come here to talk about it.
if I may, Your Honor, if
What?
the state would like to ask Mr. Linder about the pretrial motion that is required to be filed and pursuant to
No, look,
3.352.
folks, I'm letting her make her record. Let's move on. All right, let's keep Ms. Ellis here for a little bit. I'm going to call Kelly Adler. Ms. Ellis has to remain here till we put her on recall.
Thank you, Your Honor.
Where's Kelly Adler?
Is that you? Okay, come on. Switch them up. No problem, Your Honor. She's coming.
All right, I've read the probable cause affidavit on the petty theft. I find this probable cause. You also have 4 felony capias on 4 different felonies. No bond hold on each of those, and a $25 bond on the petty theft. Thank you.
Thank you, Your Honor.
Oh, no.
Landon Gall, Gawle.
No problem as well.
I reviewed the PC affidavit. I find there's a factual basis to all 4 counts.
Your Honor, if I may make a probable cause objection to count 4. I believe the probable cause affidavit is vague. It doesn't say if she misspelt the name when she gave it to them, and the name is from the one that they stated Landon Gall to Landon Gall. The spellings are very similar. As also in regards to the birth year, I would argue that it's 1 year off. It is very understandable that someone could forget their birth year by a year. And so
Wait, what?
I actually did not used to know this, but I've actually come in contact since I've been working with a couple of people who, more than a couple, that if they are homeless or Jehovah's Witness, are not aware of their birthday. So I would argue.
And the spelling of their name.
Well, no, from the probable cause affidavit, it doesn't say that she spelt out her name that way. It just says that she gave the name
Or the
as.
name that she gave was
Yeah,
mispronounced.
and if you see, no, Landon Gall, Your Honor.
Wait a minute.
It's
Were
just
you-
different spelling. An O is different from the I in the
What
name.
page are you on? Maybe I missed that.
Page 1, 2, page 3, Your Honor.
3. I didn't see 3. Oh, yes, I did. There it is.
I'm sorry, are you on Miss Landon Gall, or who are you?
Where's the
Yeah,
reference to the
Landon
misspelled
Gall.
word?
Okay, thank you.
Oh, Landon Gaw, Gaw.
Correct, Your Honor, I would just argue that, we don't know if she spelt it like that, how she said it, if maybe they misheard her. I would just, since it is so similar and it is just off by a year, I would argue that if she was trying to,
All right, I believe there's sufficient basis
Thank you, Your Honor.
to go forward. Count 1, $1,000 bond. Count 2, $1,000. Count 3, $2,500. And count 4, $100. Thank you.
What was that again for? I have 1,000 for the petty theft, and then 100 for
$3,700 for all of them.
3,700 for all of them.
Yes. it's,
Okay, thank you.
You're welcome.
Thank you, Your Honor.
Christina Lee.
Happy Easter.
This place, so somebody could call it now.
Christina Lee, I'm sorry, is that, I don't have that
Yes,
on
it's a restaurant.
page 10. Okay, let me see if I can, it must be out of.
The probable cause affidavit?
Yeah, I don't-
I don't have it as well, Your Honor.
You don't have it?
Yes, it was not provided.
Pass it around.
Thank you.
I don't see it doesn't. I don't see where it says reset either.
Oh, I see it.
Oh, you have it?
I have it. If you would, does Your Honor have a copy?
Yeah.
Okay.
All right, you said you have an objection, let's hear it.
Yes, Your Honor, I would be objecting to the tampering with physical evidence. The probable cause affidavit did state that he did not see any evidence of money and/or drug handling. And so I would just argue that there are multiple things that could leave a white substance on someone's mouth when eaten. And so we don't know. I would just be arguing that there was no probable cause to tampering or fabricating physical evidence.
Okay, I disagree. Count one is, I won't require a bond. Count two, $100. Count three, $1,000. Out-of-county hold on a felony, that out-of-county hold is $10,000. And the municipal ordinance is dismissed. Anybody here, any agency on behalf of anybody? Anybody here on behalf of a municipality on this matter? No? Okay, it's dismissed.
And whenever Your Honor is ready, I can recall Miss Ellis.
Which one's Ellis?
Your Honor, she's charged with the robbery with the punishable by life offense, Your Honor.
Wait a minute, I'm all mixed up here. I got so many different cases. I still got... Who?
Your Honor, this was the case that, with the robbery that I had asked to recall so I could speak to Mr. Linder in regarding.
Oh, about the first degree felony, the administrative order, yes?
Yes, Your Honor, I did speak with him. Apparently, I apologize for misinforming the court in any way, but the administrative order for that is no longer in place. But I would ask that the defendant still be held no bond as it's a punishable by life offense.
I won't have that without an Arthur hearing. I don't have, where's the paperwork on that? Did I give that to you? Okay, I have no idea where it is. Oh, here it is.
I mean, if Your Honor is inclined to grant a bond, I would ask that you grant a $250,000 bond if you are going to grant one, and ask that if she is able to bond out on that she be placed on pretrial with electronic monitoring. And I would ask for...
Do we have Ms. Ellis back?
I understand.
Ellis?
Didn't I just take care of this lady?
Ellis?
No, the lady that's walking away now.
Yes. Oh, no.
No, I don't think, I'm not sure what my bond was or anything.
Okay, I'll give it to you again. Your name again?
Christina Lee?
Christine Lee, yes. Can I read it
Yes,
first?
sir.
On count one was ROR. Count two, what did I do with that one? I don't remember. Resisting officer without violence, was it $250, $500?
Your Honor said a $100 bond on that count.
$100, okay. Count three is $1,000. Count four was the out-of-county hold, $10,000. And I dismissed the municipal ordinance, count number 5. Thank you.
Thank you.
All right, and Catherine Ellis?
100.
Yes, Your Honor.
All right. Count one is $100,000. Electronic pretrial release conditions. Electronic monitor. Count two. $10,000. Same thing with the monitor. Count three, the bond is $300. Thank you.
And just for the record, Your Honor, the state would object to setting a bond in this case.
Okay.
Thank you, Your Honor. Would Your Honor consider reducing the bond to $5,000 in count 2?
No.
Thank you, Your Honor.
Okay, we're gonna take a 10-minute recess. We're taking a 10-minute recess. On. Ready to control. All right, ready to go? Christina Buchholz.
That's North Broward, Your Honor.
Thank you.
Huh, I don't have these in order.
All right, Ms. Buchholz, I reviewed the PC affidavit. I find there is a factual basis. You have accounts 2, 3, and 4, and 7 and 8 outstanding warrants on 5 different there's a capias on 2, 3, 4, 7, and 8. There's an outstanding felony capias with a no bond hold. On count 5 and 6, you have violation probation felony warrants. Those have those has a no bond hold. Now on the operating a vehicle on unsafe improper equipment, I'm going to go on a limb here and give you an ROR on that one.
Thank you, Your Honor.
Thank you.
Your Honor, may I ask if you can order me to the SAP program? The substance abuse program?
I don't know what your charges are in these different felonies. I'm not the judge who handles your case. I can't sentence you to anything like that. I cannot resolve your matters in any way. Your felony matters. You have to go back to the judge that has your case.
All right, so you can't just transfer me to the substance abuse program,
Oh,
so
you
at
mean
least I'm
in
getting.
custody?
Yes.
In custody?
In-
I
in
still
custody.
can't do that. I still can't do that. You'll be in front of your judge within, 72 hours? And you can ask your judge, whoever that may be, if you can be.
When's my court date?
The 19th. April 19th.
The 19th. What time?
2 p.m.
Okay, thank you.
Willie Houston? Willie Houston?
That's me, Your Honor.
Thank you. I reviewed the PC affidavit. I find there's a factual basis. Willie? Yeah, I learned a lot reading these. I didn't know there was an area well known for that.
Seems to be a lot in Broward, Your Honor.
There's a lot in Broward I don't know about. You want to resolve this?
Yes, Your Honor.
Steve?
Your Honor, I believe this is a city case.
It doesn't say.
Oh, is it a municipal ordinance?
Statutory.
Oh, Your Honor, the state would offer adjudication credit for time served.
How long you been in jail?
2 days, Your Honor.
What's his history?
In 2009, resisting without violence. In 2009, loitering and prowling. In 2010, he had a loitering and prowling. In 2010, trespass. In 2010, he had a dealing stolen property. He violated.
In the last 2 years?
No, Your Honor.
I assume you're not objecting to it. I assume you're not objecting to that?
No, Your Honor.
I'd say. You want that? Adjudication time served?
Yes, Your Honor.
Yes, sir.
I would.
Your Honor, be inclined to give a withdrawal. Thank you.
Okay. He's the man under oath.
Raise your right hand.
Raise your right hand.
Raise your right hand.
Do you solemnly swear or affirm the testimony you should give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, put your hand down. You understand you're giving up all rights to a trial?
Yes, sir.
All right. Any drugs or alcohol or medicine in the last 24 hours?
No, sir.
You believe you're doing the right thing?
Yes, sir.
Your lawyer answer all your questions?
Yes, sir.
You satisfied with your attorney?
Yes, sir.
I'll accept this plea. It's going to be adjudication time served. Thank you.
Thank you, sir.
Don't forget court costs. Gary Altman.
Maine, Your Honor.
Mr. Altman, you have a misdemeanor capias. I guess you didn't appear sometime on out of county warrants. I can't resolve that. It says trespassing, $500 bond. Excuse me.
Your Honor, I see the county on the booking sheet listed as Broward.
Yeah, I'm looking at here. It says there's another trespassing or something. Maybe not.
Okay.
No, it says April. This is today's matter. I don't know what's going on here. It says here, April, March 30th, 2017, the capias was issued in case 17-304, MM20A. The PC affidavit says out of Broward County. That appears to be wrong. Let's be sure, because if I'm going to resolve it, I don't want to create it. It says here, Broward County capias.
Sure, Your Honor. I can look it up in the system right now.
I have it here. Here's the capias.
Yes.
It says Broward County.
Yes.
Not signed by the clerk, or deputy clerk. Okay. You want to resolve it? I'm sorry?
Yes, Your Honor, he would.
Yes, sir.
Place the man under oath.
Please raise your right hand. You solemnly swear or affirm the testimony you give should be the truth, the whole truth, and nothing but the truth.
Yes.
Okay, can you know what's his history? Last 5 years.
Sorry, just one moment, Your Honor. Most recently, Your Honor, in 2016, he had a trespass. In 2014, he had possession of a controlled substance, Cytovaldrin. He was sentenced to probation and violated his probation. In 2014, possession of paraphernalia, he pled no contest. In 2014, possession of valproxlam, he pled no contest. In 2013, unlawful use of false name and possession of paraphernalia.
All right, let's stop. I'm going to offer 5 days. Anybody have to say anything along 5 days?
No, Your Honor, the state would just ask that you order no return to the business at 150 North Powerline Road.
Jail.
Just no, once he is released from jail, no return.
I have no jurisdiction over him. Any judge that says that knows, I can say it, but I have no jurisdiction over him. If he's not on probation, I can't put any conditions on it.
All right, Your Honor.
I'll make a strong recommendation.
Thank you.
All right. How long have you been in jail now on this one?
2 days.
All right. I'm going to offer you 5 days credit for 2 days time served. You want it or
Your
not?
Honor. Yes, Your Honor.
Okay. You had any drugs or alcohol or medicine in the last 24 hours?
No, Your Honor.
You believe you're doing the right thing?
Yes.
You satisfied with your
Yes, Your
attorney?
Honor. Yes.
He answered all your questions?
Yes, sir.
Okay, I'm going to accept this plea. So we can go into the intelligently and voluntarily into. 5 days Broward County Jail credit for 2 days time served. Court costs, mandatory court costs. Now, where did this happen?
Your Honor, it was at a business
I
located.
know, I'm asking him.
Oh.
Where did this happen? Put the mic on, please. Where did this happen?
I'm sorry. Where did it happen?
Powerline Road in Pompano.
What business?
Aries Pool and Patio Depot.
Okay. I'm suggesting strongly that you not go back there for 6 months, okay?
Yes, sir.
It's a strong suggestion.
Yes, sir.
Are we clear?
Yes, sir.
Okay, have a good day. Thank you.
Thank you.
Thank you, Your Honor.
Dominique Chavez.
Maine, Your Honor.
I reviewed the PC affidavit to find a factual basis. Count 1, $500 is the bond. Count 2, $1,000. And count 3, $1,000.
And
Thank you.
I apologize, Your Honor, so you're aware for the record, he does have cases that are currently pending in drug court in front of Judge Tobin Singer.
Okay.
Your Honor, if I may. Your Honor, he cannot actually afford any bond currently. He does have the one pending case in drug court, but he's not on probation at all. He can live with his parents if he is released in South Florida here. He's been here all his life. He is gainfully employed, and all of his family is in South Florida, so he would have no reason to leave. We'd be asking Your Honor to, if he would be willing to lower the bond, considering he cannot afford what is being posted right now.
My ruling stands. He may want to look into a substance abuse program in the jail while he's there. That might help him with resolving these things in front of the judge, the relevant judge. All right, anyway, that's my ruling.
Thank you, Your Honor.
Arthur Gates.
Maine, Your Honor.
Okay, Mr. Gates, PC affidavit, I find there is a factual basis. You want to resolve this?
Yes, he does, Your Honor.
Is this a, what is this? What's the maximum we can get?
It is a second-degree misdemeanor, Your Honor.
Second degree, what's that, 60 days?
60 days in the Broward County Jail, Your Honor.
All right.
Well, hold it. This is supposed to be trespassing. Wait a minute.
Sir, Consul.
Yes, Your Honor.
If he wants to talk to me, don't push that button again. Instruct him not to talk or whatever you want, but don't cut him off from talking.
Yes, Your Honor.
Now, if you want to resolve this, sir.
Yes, sir.
I want to ask you
Yes,
some
sir, Your
questions. You have to plead open.
Yes, sir.
Which means I say that because I want to ask you some questions about it and make some recommendations to you. I mean,
Yes, sir.
theoretically, well, not theoretically, I could put you in jail for 2 months. I'm telling you, I'm not going to do that. I'm not going to put you in jail for 2 months, but I could. Do you understand that?
Yes, sir.
Your Honor, can I have one moment just to explain that?
Sure.
Explain the opening plea? Thank you, Your Honor.
Your Honor, would you like to hear his prior history, or do you want to wait?
He's got to hear
Okay.
everything. He has to hear everything.
Understood.
We're gonna kill it today, right? So I got a misdemeanor. I done been here a week, Your Honor. So that's supposed to be to kill that right there. So I don't know what he talking about. So there ain't nothing but a misdemeanor. That's all I got over my head. So that's what I'm talking for myself.
What I'm saying is, I want to ask you questions about what happened, and I can't
Yes,
do
go
that.
ahead.
Listen to me. I listen to you, now you listen to me. I can't ask you these questions unless you plead open to the court and leave it up to me. Now, if you don't want to do that, you don't have to.
I'll plead up to the court, leave it to you then.
Okay,
Whatever.
and I'll listen to what you have to say.
What's best for me?
All
I'm
right,
out
we're gonna
of
place you. You got to listen to me. We're gonna place you under oath.
Please raise your right hand. Do you solemnly swear or affirm the testimony you should give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You should be on stage. Your voice carries. You don't even need a microphone. I'm telling you, I'll buy a ticket. Okay. Where did this happen?
At Merritt, my used to be job. Well,
Used
I
to
got
be your
laid
job.
off.
But didn't the
Yes,
didn't the
sir.
owner? Didn't you get a warning about trespassing before this?
Yeah, he told me that they don't come back there. But I was going back there looking for work. You know what I'm supposed to do? I'm fresh out of prison. I'm looking for jobs. I'm looking for work.
I understand.
I'm begging the
but
man for.
You lost your job there, right?
Yeah, I got laid off.
Okay. Wait, let me read this here because I want to be sure I got it right.
I'm trying to get some work, so I'm trying to do the right thing to stay out of prison, Your Honor. That's why I kept going back there begging the man for work. So that's trespassing on that. I'm looking for honest living, man. I don't want to go back to prison.
All right, I understand. I understand you. Listen to me. Now, I don't know. You say you got laid off. I can't tell from this. But you got a history.
Yeah,
You got a history. You know that, right?
History of what?
Read a few of the things.
Your Honor, from
Listen carefully.
95, aggravated assault. He violated his probation. From 95, attempted murder. He was sentenced to state prison. And from 2014, he pled no contest to a criminal mischief.
Anything in the last couple
Yes,
years?
sir.
No, the most recently, Your Honor, from Broward is 2014.
What was that?
I don't have. That was the criminal mischief.
Okay. All right, so you understand you got some history, right?
Yes, sir. I've been on the street 7 years, Your Honor. Yes,
All right.
sir. I got some history.
Okay.
Yes, sir.
But what I'm getting at is, you can't keep doing this kind of stuff because the littlest thing gets you put in jail.
Yes, sir. I understand.
Now you can't go back. You can't go back to this place.
Okay.
If you want to write him a
Well,
letter, that's something else.
I'll find work somewhere else. I ain't got to go there. I got all kind of trades.
Well, I
ain't got
agree
to
with
go
you.
there.
I'm agreeing with you.
Jack of all trades, master of none, Your Honor. I ain't got to go back there.
Master of nothing. I know that. I know a lot of people like that. There's another way. Right. Jack of all trades, master of nothing. That's it.
Yeah.
I understand, but you got to make best efforts to stay out of trouble, and this is going to get you in
Yes, sir.
trouble.
Hey, I'm not going back to prison or jail. Not if I can help it. It's in my control. I ain't going back.
Well, okay, I don't know what to say to that. You've been in there, how long you said? How long you been in there?
A week and a couple of days or so, something like that.
You got a place to go when you get out?
Yes, sir. Yes, sir.
I'm sorry? It says you were arrested yesterday in here.
I was arrested yesterday. No,
Saturday,
she got
April
it on.
15th. At 5 o'clock, you were arrested.
There was, was it Saturday? Oh, he got the paperwork. Y'all, who got the paperwork? Let me see.
Fortunately for you, I got the paperwork.
Okay, what did it say, Saturday? What it was?
Yeah, you're confused. You're paying your taxes?
Do I pay taxes?
April 15th.
Yes, sir, I pay. I got this April 15th. Let me see. I ain't got no date on. January, February. Okay, yes, sir. Yes, sir.
I still like it.
We on key. Yes, sir.
Okay. State, you got a recommendation?
I would just go with your discretion, Your Honor.
I don't even remember what it was. It's so long ago.
You didn't say what you were going to offer.
You go with it.
I would leave it in your discretion. The state would ask for some time in custody based on his prior history.
30.
What?
No, go ahead.
All right, you said you were there for a week? Is that what you said?
Yeah. I was in there with jail in here.
You thought you were there for a week, right?
Yeah, that's how long it is. I hate jail, Your Honor. It seemed like 2 years, a week.
Leave it at a week. All right, any reason why I can't go sentence? No, there's no reason. Okay. He's got 1 day in. He got in yesterday, so he's got 2 days in if you count today. That means they can let him out at midnight if 3 days.
Wait a minute, there's something wrong. Go ahead, well,
Adjudication. 4 days Broward County Jail, credit for 2 days time served. Okay?
Say 4 days, Your Honor?
Yes, credit for 2.
So how much time?
You have 2 more days to do then.
2 more days to do? Oh man, good. All right, whatever.
That's too much?
Yeah, that's too much on the on trespassing, Your Honor. I think that's too much.
You think that's too much?
Yes, sir. I'm ready to walk now.
Are you ready now?
Yes, sir. I've been ready. I got to go to work, man. I got to find a job, Your Honor. I ain't got to be I ain't panhandling. I can't be walk. If I got enough strength to walk up and down that panhandle, I got enough strength to find me.
All right. That's the best argument I heard all day. I'm gonna
That's
change.
the
I'm gonna change
truth.
the sentence.
Oh, that's the truth. I got to
years.
go. I got to work.
You ready?
Yes, sir.
I'm gonna make it 3 days instead of 4 days. So you'll get out tomorrow.
Get out tomorrow. Good enough. Good enough, sir.
You sure? Because I don't want to pressure you.
Good enough. I work with that. I work with that.
Thank you
Tomorrow,
for helping
what
me out
time?
on that one.
Tomorrow morning?
No, it might be midnight. I don't know. That's up to them. It could be.
All right.
I don't want them to let you out at midnight. It'll be a mess.
Yeah, but you controlling the show.
I can't. No. They can let you out. It's up to the Department of Corrections.
Okay. All right.
So get a good night's sleep, breakfast, and then get out. They'll let you out.
Do I get some paperwork? Do I get any kind of paperwork?
You'll get paperwork.
All right.
You want me to bring it to you myself?
Yes, sir. No, yeah, you bring it yourself.
Maybe they're a little longer.
No, that's all right. The deputies, they can handle it. They definitely got them. All right.
Thank you, Your Honor.
What are you doing Saturday? Stephen Morris.
Maine, Your Honor.
Sir.
Your Honor, this is a municipal ordinance case. Mr. Morris would like to resolve it.
What city is it?
It says Fort Lauderdale on the docket, Your Honor.
Fort Lauderdale, Your Honor.
Anybody here from Fort Lauderdale to prosecute this case? Resolve this case. Anything from Fort Lauderdale? Anybody? Once, twice? No? Dismissed.
You're done, sir. Step out. Step away. Palmer.
Ronald Palmer.
Yes, sir. Your Honor, this is also a municipal ordinance. Looks like Fort Lauderdale, and he would like to resolve it.
Got a tattoo. It's got a gun, and it says Grim Reaper.
No, the Grim Reaper's on my arm. The gun's on my forearm.
Oh, okay. Thanks. That clears it up for me. Got skulls on your fingers?
Yes, sir.
And you have a snake with a dagger.
Yes, sir.
Any others I don't know about?
I got a dragon on my chest.
How'd they miss that? All right, this is Fort Lauderdale also? Anybody here from Fort Lauderdale?
It is Fort Lauderdale, Your Honor. If you would like
Anybody here to prosecute this case in Fort Lauderdale?
If you would like to reset the case for Monday, I believe someone from the office will be there.
Your office can't do
No.
this.
No, I'm saying someone from the Fort Lauderdale.
Call them. I'm not waiting. They don't come on weekends.
Right.
And,
Okay.
that's treating people differently, I think. Anyway, I got to tell you, did I already dismiss this one? Your sign, I've never seen a sign like that. You ready for this?
Yeah,
Bank grabber,
yes, sir.
need money for bullets.
It just makes people laugh, sir.
Not me. Maybe tonight when I go home. I don't know. God bless you. And me. That's pretty creative. Why don't you make why don't you do something like that? I mean, I don't know. I don't know what to say to you. I'm dismissing this thing. I'm throwing it out.
All right, there you go.
Thank you, Judge.
You should try and get a job, something. Yeah. Why do I have a feeling?
Even up here.
Okay, Joseph Anderson.
Burglary of an unoccupied.
Broward?
North. Is this Joseph?
Yes.
Yes, sir.
All right, it's got a violation of probation with a no bond hold. Is that a misdemeanor?
Yes.
No, not you. I'm asked to state.
Yes, Your Honor, it's a misdemeanor. If you see the last page of the warrant, Judge Lerner did ask for modification by herself only.
What's he on probation for?
Your Honor, he is on probation for driving under the influence, and the violation is on that page that he,
He's on probation for what?
for driving under the influence.
All right, and the judge wants to deal with it herself?
Yes, Your Honor, if you see the last page of the warrant, she did request that she deal with the violation, and the violation is serious in nature.
Oh, I see why. You see what it says under the warrant?
Yes, Your Honor.
Okay. No bond hold, thank you. Thank you.
Is that it, Your Honor?
No bond hold, yes.
Thank you.
Raymond McNeil.
Maine, Your Honor.
Mr. McNeil, you got a capias on a misdemeanor. You want to resolve it?
Yes, he would like to resolve it, Your Honor.
It was the solicitation on a public right of way. Does that mean money? Asking for money?
Yes, Your Honor.
I don't think he was selling anything else there.
There, and this is a municipal ordinance, Your Honor, as well.
Oh, it is?
No, but it's, there's an outstanding capias. It's not for me to dismiss the municipal ordinance at this time.
No, I understand, Your Honor, I was just like.
It doesn't have to be anybody here to prosecute that at this time. You want to resolve this, you said? Yes?
Yes, sir.
Can you give me a ballpark the last couple of years, what he says?
Sure, Your Honor. Most recently, Your Honor, in 2013, failed to comply with order. 2013 failed to comply with order. That's the most recent prior.
All right, how long you been in jail now?
I got ready yesterday. Yesterday.
Did you have a sign
Got
right
ready
there?
yesterday.
Anything about bullets?
No way.
All right, I'm going to give you
I
time.
love.
You interested in time served?
Yes, thank you.
Raise your right
I
hand.
could.
Swear to tell the truth?
Yes, I do.
All right, put your hand down. Do you have any drugs or alcohol or medicine in the last 24 hours?
No.
Believe you're doing the right thing?
Yeah.
Yeah?
Mostly. Yeah.
Satisfied with your attorney?
Yes, I am.
You answer all your questions?
Yes.
Okay, I'll accept this plea. It's adjudication time served, thank you.
All right, thank you, Judge. Thank you, Judge.
Yep. Noah Littlepage.
Good morning, sir.
Yeah, this
Maine,
one
Your
was a little weird, I thought. Capias on a traffic ticket, $250 bond.
Your Honor, he said that he would like to resolve it if Your Honor is willing.
I don't know if I can resolve a suspended license charge, can I?
Your Honor, I wouldn't prefer we not, because I don't know his driving record or if this was a crash case or if this is going to habitualize him in any way, so I would not feel comfortable making an offer on it.
Who's the judge?
Your Honor, I do believe that yesterday we did handle some driving with license suspended cases.
No.
Your Honor, the reason that he is wanting to resolve it is he is starting a brand new job tomorrow.
With Interactive Suites, I do home automation.
Where?
Okay.
Interactive Suites. It's off of Davian University.
What is it?
Home automation. It's where I turn houses into smart houses. I wire houses and I program it, for like anywhere in the world you could use your phone to turn the lights on, unlock the door, stuff like that. It's a very nice career that I'm trying to start tomorrow.
Jason, make sure you go over the enhancements of the driving.
Got it.
Thank you.
Well, can you post a bond?
Right now, no, I can't. Unfortunately, I can't. And another thing is I do have to file for my taxes, and I think I have until the 18th. You know,
Actually, it's the 15th.
Okay.
I guess he wants to talk to his client.
I believe he's going over the enhancements with him, Your Honor.
I'm inclined to give him all the warnings, all those concerns you had that he may be facing.
Yes, Your Honor, if you could.
It would be a felony if it was his third time, right?
It depends on the circumstances, Your Honor. It could result in the suspension of his driver's license for up to 5 years.
This is a misdemeanor.
But a third could be.
If it's a third one, no. If he has two, this isn't a misdemeanor. He's not charged with a felony.
Correct.
If it's 3 and 5 years, it's a felony, right?
Well, it's not per se a felony, it's just that they lose it for 5 years, Your Honor, but they can choose to charge it as a felony if they would like.
Well, I don't know that he wants to do this then.
Well, that is what I just went over with Mr. Tom, he's going over the enhancements right now, Your Honor.
Okay.
Because from his driving record, Your Honor, it does appear he has the driving while license suspended in 2014. This would be the second charge in 5 years. I don't know if there's any other cases pending out there that aren't on his record, so I would just ask.
This is a brand new charge. It's a 17 case.
Yeah, I would just ask that.
Yeah, this could be a problem.
Yeah.
I understand that, Your Honor, and that is why defense counsel is going over the enhancements with him. If it is only his second, and we will let him know that if there is a pending one, that will be the third, subsequently revoking it for 5 years. But if Your Honor is inclined to allow it, if Mr. I'm sorry,
Oh,
Mr.
wait, now
Littlepage
you're doing all the talking now. You're doing a lot more than I thought.
would like to resolve, I would be inclined to.
Yeah, he's still going. Counsel?
Yes, Your Honor.
What are we doing? Did you go over the dangers of pleading?
I did explain to him the habitual traffic offender, Your Honor, and this could suspend him for 5 years. Also, that there is a possibility that anything after that may be charged as a felony while he is suspended, and that we have no way of figuring that out right now.
All right, then I'll leave the bond. I'll even lower the bond if you want. Okay, the bond's $250. Thank you.
I can't resolve this, Your Honor?
What? Well,
I can't resolve this?
You just talked to your lawyer. Didn't he explain to you the risks?
Yes.
Well, you can do what you want, but I mean, I would listen to your lawyer. He knows what he's talking about. You're the one who knows your background. You know how many times you've been driving with a suspended license.
One moment, please, Your Honor.
Come on, we're taking way too long.
Your Honor, I've explained everything to him and all the possible penalties that I'm aware of. Understanding that we don't know if he has pending charges and that can be upcharged, and he says he still wants to resolve with Your Honor.
I'm really anxious about this job, Your Honor.
Listen, I don't care what you do. I just want to be sure that you understand the risks involved, because we don't know your background here. Your lawyer made it clear that depending on the number of...
James.
Well, I'm not going to go through it all with you. Did you have any questions?
No, sir.
Okay. Raise your right hand. Swear to tell the truth and only the truth?
Yes, sir.
Okay. Put your hand down. Do you have any previous tickets for driving on a suspended license?
I believe I had one before in Colorado.
It's still pending?
No.
I thought he has 2 in Florida.
Your Honor, from what I can see on the driving record, and this is just from solely looking at the driving record, he has one from 2014. I don't know if there's others that are not on the driving record.
Oh, this one is 2017.
Yes.
Do you understand that?
Yes, sir.
When was your one from Colorado? When was your one
yes,
from Colorado?
Broward County.
All right. Do you? All right.
Oh, really?
I'm not going to do this. I'm not, because he doesn't know what he's talking about. He's got two pending in Broward and one from Colorado. That would make 3. Your bond's $250. Thank you.
Thank you, Your Honor.
Nicholas Silveri.
That's Maine, Your Honor, and he would like to resolve if Your Honor's willing.
Okay, place this man under oath.
Please raise your right hand. Do you solemnly swear or affirm the testimony you give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Place your hand down.
Is this a municipal ordinance case, Your Honor?
Who?
Is this a municipal ordinance? I don't see it. Doesn't show.
There's loitering and prowling. I assume. So I'm assuming it's statutory. It doesn't say municipal ordinance.
Okay. Thank you, Your Honor.
I don't know.
It doesn't say, I don't see anything on it, Your Honor, to indicate that's a municipal ordinance violation.
856.021. Statute number. He's going to have to plead open so I can ask him some questions.
One moment while I explain that to him, Your Honor.
This is a... What degree misdemeanor is this?
It's a second degree, Your Honor.
I gotta stop doing this. Oh, look, loitering and prowling.
I believe they're code offense.
KPS traffic ticket. Public intoxication. Battery.
Your Honor, I've explained the risk of pleading open, and Mr. Silveri said that he would like to plead open to Your Honor.
Right. That's correct?
Yes.
You understand I could put you in jail for 60 days?
I do.
You're not being forced to do this, you understand that, right?
I know. Yes, sir, I know.
Drugs, alcohol, or medicine in the last 24 hours?
Other than the medication they gave me here, no.
What's that?
A vitamin and something, I think it's sleeping pill.
Is it affecting your ability to understand what's happening right now?
No, sir.
Okay. What were you doing over at this building? Well, Wait. Let me first accept the plea. I mean, you believe you're doing the right thing?
I do.
You satisfied with your attorney?
I do.
Yeah. No. All right. Did he answer all your questions?
Yes, he did.
All right. If you have questions and you want to talk to him, you let me know, and I'll let you talk to him, of course. All right. Okay. What were you doing? I'm going to accept this plea as being knowingly, intelligently, and voluntarily entered into. You understand? I find that you understand the consequences of the plea as well as each right you're giving up. I mean, you understand you can't present a case, you can't defend yourself, right?
Yes, sir.
All right. What were you doing at the building?
I was living there or sleeping there, and I was just trying to get out of the rain and that. But I've moved in with a buddy, and I'm staying at his house now. And I was looking in on a friend that was staying there too.
How long you been in jail now?
2 days. Got here yesterday.
Recent history?
Your Honor, I could not see any from Fort Lauderdale.
Any reason why I can't post sentence? No? No? Okay. Withhold adjudication. And wait. Thank you.
Thank you, Your Honor.
What just happened?
Withhold and waive. Antonio Washington.
Maine, Your Honor. Same situation you would like to resolve, Your Honor.
How tall are you?
6'6". I didn't shrink from yesterday, Your Honor.
I can't even see the top of his head. What's this? Let me see what he did here today. Again. Is this a first degree? No, it's second.
It's a second degree.
All right, he's going to have to plead open. I have questions.
I explained the risks of that to him, Your Honor. He said that he would like to open plea to Your Honor, knowing the risk.
Okay, you understand that I could put you in jail for up to 60 days?
Yes, sir.
So to tell the truth, the whole truth, and nothing but the truth, raise your hand. You're ready.
Yes, sir.
Okay. You're not being forced to do this. You can have a trial if you want. You understand? You had any drugs, alcohol, or medicine in the last 24 hours?
No, sir.
You believe you're doing the right thing?
Yes, sir.
Satisfied with your attorney?
Yes, sir.
He answered all your questions?
Yes, sir.
Now you gotta understand, you can't present a case. You can't present a defense. You can't compel the state to put on a case. You understand that?
Understood.
Okay. I'll accept your plea as being knowingly, intelligently, and voluntarily entered into. I believe you understand the consequences of the plea. Is all sheet right you're giving up?
Yes, sir.
What were you doing there?
Sleeping.
Who were all those people that were going in and out of there?
I don't know. I just know it was me and him that was just in there. I don't know the rest of the people.
There was no drugs found there. Someone complained about people going in and out of there. Is that right? No drugs found? That's the way I read it. They got calls about people going in and out.
Correct, Your Honor. I don't believe they
But
found
when
drugs.
they went there, they didn't find anything. Just these two guys.
Yes, Your Honor.
Any history for the last few years?
A prior arrest, Your Honor, no prior convictions at all.
Nothing else?
Nothing else.
Any reason why I can't impose sentence at this time? No? No? Okay. Withhold and wait. Thank you.
Thank you, Your Honor.
Timothy Barabbas.
Maine, Your Honor. Your Honor, he's in the restroom if you want to put it on recall.
All right. John McKinney.
North Broward.
You got a outstanding capias on a traffic matter, sir.
Yes, sir.
What's the traffic matter?
It's driving while license suspended.
Driving?
While license suspended.
Okay.
But I was walking at the time.
Sir, this time I'm going to instruct you not to speak about the facts of your case, please.
It's a capias.
What's that?
It's a capias on a driving while license suspended.
Okay. So he was picked up when he was walking that. All right. You want to resolve this?
Yes, sir.
All right. Does anybody explain to him the consequences? I don't know how many suspended license driving and suspended license matters he had. Do we have his record here? Oh.
I can't even see his record.
Your Honor, if I may go over the enhancements with him?
Go ahead. Do you have his record?
No, I do not. I'm just going to go over the consequences of resolving today.
Well, here, you want to see it?
I will after Your Honor is done reviewing as well.
Hi, Mr. McKinney. This is Marlene Mercado from the Broward County Public Defender's Office. I just wanted to advise you that if you resolve this case today, if you obtain 3 driving while license suspended tickets in 5 years, you can become a habitual traffic offender, which could cause you to lose your license for 5 years. Also, it could be charged as a felony. Also, if you get any DUIs or reckless drivings, those can count towards the 3. We are looking at your driving record.
I have
but if
not
you
seen
resolve
his
today
driving
and there is
record.
anything pending that we don't see, I just want to let you know you could lose your license for 5 years if this is number 3.
That was suspended.
Do you understand?
Yes, I believe so. What are my other options?
Well, just a minute. I looked at the driving record. I want you to take a look at it too. It's right up here with the state, but I think he lost his license because he didn't pay a traffic fine, and that was the reason he lost it. And he did not pick up driving on a suspended license outside of this one.
I was unemployed at the time, so I could not afford to pay the fine.
Okay, sir, please don't say anything about the facts of your case.
And if Your Honor could just please inform the defendant that this is what is appearing on his driving record. The state is not aware of his other prior history or what might not be on the driving record that could affect his license.
And Your Honor, defense would like to state that as well.
I've only been able to see the driving record that's been printed today, sir, so I don't know if you have any other pending cases. If you resolve this one today, it does appear this will be your first strike in the 3. However, like I said, I am unaware if you have any other pending ones, and if you do, and subsequently resolve those, 3 and 5 years does equal a 5-year license suspension. Do you understand, sir?
Yes, ma'am.
And do you still want to resolve your case today?
If I can, I have work, so I need to try to be at work.
Are you able to bond out on this case?
Whoops, I'm sorry.
Probably not, because I don't make enough money, and I have to pay rent and everything else.
Okay, I understand. I would still advise you against resolving this case today, sir, but if you would like to, you can.
Well, then what would happen if I don't resolve it?
Your Honor, we'll set a bond, and then you can
No,
either
the bond
bond
is
out.
here. I could lower it, or I could raise it. The bond is $500 as it is right now.
Okay.
As far as the bond goes, your lawyer can move to have it lowered. The state can move to have it raised. But it's at $500, and I can leave it at that if you want. Whatever you want.
Would you like me to?
It's up to you.
Do you want me to request a lower bond, or would you like to resolve your case today? And just know that if I request it, it's not guaranteed that it will be lowered.
It's not going to go up.
I'd like you to request it be lowered.
Okay, go ahead. Let's hear it.
Sir, are you currently employed?
Yes, ma'am.
Okay, and do you have a place to stay if you get out?
Yes, ma'am.
And how long have you lived in Florida? How long have you been in Florida for?
10 years.
10 years. And do you have family here?
No, ma'am.
Okay. Your Honor, defense respectfully requested the bond be set at $100. He is currently employed. He has lived in Florida for 10 years. And though he doesn't have family, this is a misdemeanor case, so defense would respectfully request.
State would just ask that the bond remain at $500.
Okay, $250.
The bond is set at $250, sir.
Okay.
Thank you.
Thank you.
Here.
Timothy
Your Honor.
Barabbas.
Yes, Maine, Your Honor, he's back.
Thank you. Mr. Barabbas, I reviewed the PC affidavit in this matter, and I find there is a factual basis.
Oh, yeah, I see. Yeah, it was, things take wrong context.
Petty theft, first degree.
Put me on this jacket.
Is that up to a year?
Yes, Your Honor.
Trespass, failure to leave. All right, any recommendation? I'll discuss the bonds.
Your Honor, I just ask for $100 on each count. $100 on each count.
$100 in each count it is. Thank you.
Your Honor, would you be willing to release Mr. Barabbas today?
Because I have no sort. Oh, I'm sorry.
He can't afford any bond, even if it is the nominal $100 bond. He's not on probation at all. He's been in Florida for 50 years, so he wouldn't really have much reason to leave here, Your Honor.
Well, the allegations are that he went back to a business where they had a permanent no trespass put on him, and then he came back and he alleged that he stole stuff from there. Am I reading this correct? Let me see.
Well, I wasn't aware that I.
Talk about the facts of your case.
On November 5th, 2016, he was issued a permanent trespass warning, and it's got the case number not to return to that property. Now, if he wants to resolve it, fine, but I'm leaving the bonds where they are.
Pardon me?
Your Honor, if you're willing to make an offer, he would like to resolve this case.
State, any recommendation? Probation? Nothing?
Your Honor, I would hesitate to resolve the case now just because I'm not able to have contact with the victim.
Well, they got everything back.
But the state would ask for at least an adjudication and some time based on his prior history. The case could, he does have several petty thefts. Most recently in 2014, he had a petty theft and a resisting. In 2015, a trespass. in 2016, failure to leave property upon order. In 2017, he had both a petty theft and a trespass, and then this current petty theft, Your Honor. So
You got a lot of these, sir, you understand that? Defense, anything you want to say? We gotta move these along, come on.
and the state would ask for
No,
30 days Broward County Jail based on the
Can we
recent
go over
thefts.
the petty theft enhancements, Jason?
I have went over the petty theft enhancements with him. He understands the possibilities. I've
Sounds like
explained
he's
that to
got
him.
enough, I mean, after this, it sounds like he has a
Better
history of
what?
petty theft. What do you want to do?
I've explained the penalties to him. He's wanting to resolve if Your Honor is willing to make an
Is that
offer.
correct?
Yes, sir.
Raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth?
Yes, I do, Your Honor.
You working?
You understand the open pleading, right?
You working?
Your Honor, is this an open
No.
plea, Your Honor?
Yes. This
You
means I
understand
can
the-
put you in jail for, 1, 2,
You heard me explain that, right? You understand that you
3
have to
years.
accept
Is that
whatever
correct,
the
State?
judge is offering.
Yes, Your Honor.
If I put you in jail, it could be 3 years, 1 year in each one of them. Consecutive, that would be the maximum you would get. You understand that?
Yes, sir.
I'm not gonna give you 3 years. But I can't
You
give you up
understand
to
you have to
that.
accept what the judge gives you, right?
Pardon me?
You could get up to 3 years.
Yes, I
But I'm
understand
telling you
that.
that I won't give you 3 years. I can give you 299, whatever three times 365 less 1 is. You understand that?
Yes, sir.
You're not being forced to do that, you understand?
I know, yeah.
Any
I know,
drugs,
Your Honor.
alcohol, or medicine in the last 24 hours?
I had some alcohol yesterday.
You still feeling the effects of it?
No, sir.
You sure?
Yes.
You do understand you
You're not
have
being
to
forced
accept
to
what
do
the
this.
judge gives you, right?
Pardon me?
One moment, please, Your Honor. You do understand that this is an open plea. You have to accept whatever the judge hands down, correct?
Yes.
Do you still want to go forward with this, understanding the penalties?
Well, if I can resolve a case.
Three matters. Three charges. You want to do it or not?
Pardon me?
You know, by doing this, you're giving up all rights to a trial. You can't fight it. You can't make the
Yes.
state present a case. You can't confront the witnesses. You give that all up. Do you understand?
Yes, so what am I looking at right now?
I could give you up to 3 years in prison, in jail.
I understand that.
Well, I'm going to tell you what you're going to get when I'm done. But I first want to see if you want to do it. I'm going to ask you questions after
Yes, sir.
I take your plea, and then I'm going to sentence you, okay?
Yes, sir.
You
believe you're
understand
doing the right thing?
possibilities?
Pardon me?
You believe you're doing the right thing?
I'm not really sure. I
You
just
want to
like
take more
to.
time? You want to think about it?
Well,
That's all right. You want to have a seat and think about it? You want to have a day and think about it? Whatever you want.
I just like to be able to get out of jail.
Well, we all, I know that. But I'm making no promises. You've been sitting there all
Okay.
day, right?
Yes, sir.
All right, do you want to go forward with this?
I don't know what the hell.
Sir, if you don't want to, that's fine. I got nothing personal involved in this. It's up to you.
I just want to stay out of jail, whatever that comes to.
All right, well, I can't tell you that. I can't guarantee it.
I don't know what to do. Ah, Jesus.
Do you want some time to think about it?
Yes.
Put him on recall, please, Your Honor.
Should I give him a day so I can leave?
You want to come think about it, come back tomorrow?
All right, let him sit there and think about it. It's all right. Jordan Tuthill.
That's Maine, Your Honor.
Excuse me?
That is Maine, Your Honor.
I reviewed the PCF data to find there's a factual basis. You want to resolve it, or you want to post your bond, or what? $25 is the bond. Can you afford that?
Yes, sir.
All right, you want to bond out, or do you want to resolve it?
Resolve is better, right?
Resolve means the case will be over today.
Okay, yeah, we resolve it.
Oh, all right. Tell me about this man.
Well, Your Honor, it doesn't appear he has any history out of Broward County. I mean, I don't know what his other history might be, but if he chooses not to resolve it and goes to court in a later date, I mean, he may be eligible for the diversion program. I just don't know. otherwise I don't see any prior history. I mean, I can't put him in the program today, obviously, I don't have his complete background,
You hear what the
but
state said?
I'm explaining does that mean he may be eligible for MDP?
I don't know because I don't have his full record, but it doesn't appear he has any priors in Broward. That, I'm just saying if he wanted to bond out, that could be a option for him in this case. I just don't know.
You been getting in trouble anywhere else?
No, sir.
Because I'm gonna check it right now. And
That's okay.
So you have any problems in the past? Any arrests?
No.
Okay. You believe? All right. Did
So-
I place him under oath? I don't even know.
Please
Wait.
raise your right hand.
This lawyer's talking to him.
I just wanted to
That took too long with these.
remember mine.
What? I wanted that question.
I got it already in my head. Thank you.
He's not going to dismiss.
Okay, so then yeah.
Your Honor, he indicated that he would like to just post a bond and
Okay.
see if he can get in the MDP.
Okay. I don't even know what that means, but okay. $25. Thank you.
Thank you, Your Honor.
Britt Oates. Is that a cereal?
Maine, Your Honor.
Okay. Is this a felony or? Why is the bond $1,000? Is this a misdemeanor or a felony?
It's a misdemeanor battery, Your Honor.
Why is the bond so high?
I believe it's based on the nature of the facts of the case.
Okay. I find probable cause, your bond's $1,000. You want to resolve it today?
Your Honor, I can't.
What?
I don't think that we can resolve the batteries without having any contact with the victim. The victim does have a right to be present.
You're right.
And his bond was posted, Your Honor.
The bond was posted? Do you understand that, sir?
Yes.
Someone posted your
I'm sorry, I
bond.
didn't.
Listen to me. Someone posted your bond, so you're getting out today.
Okay, thank you.
You still
Thank you,
got
Your
to
Honor.
you still got to appear in court. You still have to appear
Okay,
in
no
court.
problem.
Oh, and Your Honor, can we just also ask for no contact with the victim? I know the bond has been posted, but as it is a battery case, the state would be acting.
You understand that? Can you hear me? You understand you
Yes,
have no
sir.
contact with this person? You understand that?
Yes.
I'm ordering that. That's the condition of your bond, no contact in any way, manner, shape, or form by you or anybody else except your lawyer. Okay, you got it?
Yes, sir.
You got it. Thank you. Michael Ruiz.
North Broward.
Do you speak English?
Sí, hablo inglés.
¿Cuál es más cómodo?
Both. I can
You
speak
want both?
English.
Sounds
You
like
want?
we're
Then get it, especially. All right,
The
you
thing
comfortable
is
in your
that
English?
I can't really fucking.
Oh, okay. He'll speak loud. He understands English fine.
Oh, he does?
I think he's. Are you deaf or something?
Yes.
Okay, he's not deaf, but he's hard of hearing.
I heard that.
Give it a shot. Let's see what happens.
Severely profound. I
Okay,
mean, it's
listen
hard of
carefully.
hearing.
Listen carefully.
Sir, please don't talk about the facts of your case.
Okay, I reviewed the PC affidavit in this case, and I had some questions.
And Your Honor, the state would object to any resolution of this case is there is an individual victim listed in the PC and she would have the right to be present.
One whose water he took?
It is he stole her water utilities or is alleged in the probable cause. So the state would ask that you not resolve the case as there may be restitution since there was an increase in her water bill and she has the right to be present in any plea negotiation or for any critical stage of the case.
Your Honor, could always resolve and then or reserve for restitution?
That would not, Your Honor, the state would still object as that would not address her constitutional right to be present. The bond is $100, Your Honor. I feel like that is an appropriate bond for this case.
Hold on. What'd you want to say?
Oh, well, I thought Your Honor was, having questions about the probable cause
Well, I
affidavit.
didn't think about the victim, so. No, the probable cause, I mean, walking away, resisting without violence, and the taking of the water. Unauthorized connection to utility equipment is not a theft charge. I wasn't sure what that was. Do you know what that is?
I believe it's a theft of utilities, Your Honor.
It is,
It's
Your
just
Honor. I
put-
looked up the statute to see if, water did apply, and water does apply.
Okay, now I know. Okay.
I didn't know if Your Honor was gonna say something then, I was.
Well, I wasn't sure about that one. I put a question mark next to it. All right, the bond in count one is $100. The bond in count two, $250.
Would
Thank
Your
you.
Honor be inclined to reduce the bond in count two?
No. Thank you. Thank you.
Sir, your bond is set at $100 in count one and $250 in count two.
Okay, Thomas Rose.
Did you hear that, sir?
$100 on count one and $100 on count two.
No. $250 on count two.
All right, on count two, it's 250. I'll write it down.
Thomas Rose.
Thomas Rose was a reset, Your Honor.
Lester Ellison.
North Broward.
That's a reset as well.
I can handle those. Wal, or W-A-E-L, Hamid.
Maine.
Mr. Hamid. Am I pronouncing that right?
Yes, sir.
Okay.
Hamid.
The petty theft charge, are you the probable cause affidavit? I find there's a factual basis. And you have a misdemeanor KPS and two felony, a KPS and two felony charges. That's, the felonies are no bond hold. The misdemeanor is $500. The petty theft is $100. Thank you.
Thank you, Your Honor.
Ian Gray.
Maine.
Good morning, sir.
I reviewed the PC affidavit. I find there is a factual basis. Something between you and your father. You want to resolve this?
Your Honor, it's a felony.
Oh, the father, it's a felony?
Yes, Your Honor. And there's a victim, so
Over $1,000, you're, okay. The bond is $500, sir. Thank you.
Thank you, Your Honor.
That's it. Nicholas Sarkozy? Is that a friend of Trump? Oh, no, an author, Sarkozy.
That's Maine, Your Honor.
President? Better get Russia. Where's Nicholas? Oh, there he is. County ordinance. Oh, boy. What's the violation probation? The county ordinance?
it may be, Your Honor.
Well, that's important.
It is.
Very important.
But our office prosecutes the county ordinances.
You do?
Yes.
Okay, so you're going forward with this. Let me see the PC here. Okay, the bond is $25 on the county ordinance, and there's a no bond hold on the felony violation of probation or community control. Thank you.
Thank you, Your Honor.
Can we go back to Timothy Barabbas? What do we do with that one? Oh, did he decide what he wants to do?
Sir, I would promise to stay out of all these establishments and not ever commit.
Are you pleading open?
Pardon me?
Do you want to plead open to the judge or no?
Yes.
Okay. You know, I already placed you under oath, didn't I? Did I place him under oath? Yes.
Yes.
All right, you're not being forced to do this. You can have a trial you want. Do you understand?
But it might be the same outcome if I go to a trial.
It might be worse.
I know.
Your Honor, I did
Do you
explain to him
understand
that.
you're not being forced to do this? You can have a trial if you
I,
want. Do you understand that?
yes, sir.
All right. Have you had any drugs, alcohol, or medicine in the last 24 hours?
Yesterday, yes.
What'd you have?
Alcohol.
Is
It was
affecting
alcohol.
your ability to understand what's going on right now?
No.
You believe you're doing the right thing?
I hope so.
Okay. You believe you're doing the right thing?
Yes, I think
You
so.
satisfied?
Yes.
Well, I either believe it or you don't believe it. You want to do this or not? I know you don't want to
Yes.
do it, but you believe it's in your best interest.
Yes, Your Honor.
Satisfied with your attorney?
Yes.
He answered all your questions?
Yes, he did.
All right, now you're giving up all rights to a trial. You know, you can't make the state present their case. You can't present your own witnesses. You can't confront the witnesses against you. Give that up. Understand?
Yes, Your Honor.
Okay, I'll accept this as being knowingly, intelligently, and voluntarily entered into. I find you understand the consequences. Please, all these rights you're giving up. It says here you returned the stolen beer. Is that correct?
I returned it, yes.
Can you give me a little bit of his background, last few years?
Sure, Your Honor. Most recently in 2017, he had a petty theft he pled. In 17, he had a trespass he pled. 2016, failure to leave property upon order. 2015, trespass. 2014, petty theft and resisting. 2005, trespass. And 1992, possession of cocaine.
I got it. You got a job?
Not at this point. I can't find one yet. But I'm working on it. I sure wouldn't be stealing if I was working right now.
No, rich people don't steal, I know. Maybe I'm mistaken on that. What's the state looking for?
The state would ask for 15 days Broward County Jail based on recent prior theft.
How long have you been there? How long have you been there in jail now? Don't exaggerate.
Since yesterday.
So yesterday and today, it's 2 days, right?
Yes, Your Honor.
You got a place to live?
I'm looking for that too.
Okay. Any reason why I can't post sentence? No?
No.
No? All right, in all three counts, this adjudication, 5 days Broward County Jail, credit for 2 days time served.
Thank you.
30 days to appeal. They're already concurrent. 30 days to appeal. If you're so inclined to appeal, but can't afford an attorney, let the court know an attorney will be appointed for you. I was supposed to say that in all those.
Thank you, Your Honor.
Albert Serrano.
Maine.
Mr. Serrano, you have a military hold. There's no bond on that.
Yes, sir.
Thank you.
Your Honor, just so you're aware, he is a veteran, obviously, with a military hold.
Oh, I don't know that he's a veteran.
He is a veteran, Your Honor. I believe it was in the Army. Just so the court is
I
aware.
wouldn't make him a veteran. He'd have to get an honorable discharge or something, or a certain he hasn't served. He's got a hold. He's in the military now. He's got a military hold. I don't know that he's a veteran. But anyway, let's move on.
Thank you, Your Honor.
An active warrant for desertion, it says. I don't think they'd call him a veteran. And I'm not being critical. I mean, I have no idea what it's about. Drayon Smiley.
Maine, Your Honor.
So this is the sexy DB.
Co-defendant.
This is the co-defendant, Your Honor.
One of them, okay. What did I give the other guy? I don't even remember.
She had no prior history. You gave her $100,000 on count one over the state's
That's
objection for the no bond.
I know. All right, I reviewed the PC affidavit. I find there is a factual basis. Defense, what is the state looking for? The same thing?
The state would ask for a no bond, Your Honor. I'm checking his priors right now. I don't know what his prior history is. But we would ask for count two and count one are both first degree punishable by life felonies. So we would ask that you hold the defendant no bond.
The lady charged with?
Same thing, Your Honor.
Two life felonies? But I
Yeah.
gave a different bond on the second one, didn't I?
Yes, Your Honor. And
I can't recall what it was, but you did.
And
All right.
defense would renew their objection that in order to request a no bond hold, the state does have to file a motion pursuant to Florida Rules Criminal Procedure 3.132 and/or proof is evident, presumption is great, which they have not done at this time.
What did I give the lady on the bond, the second count?
One moment, Your Honor. We gave her $100,000 in count one, $10,000 in count two,
I thought.
with pretrial release, and $300 in count three, Your Honor.
Your Honor, if I may give some information.
Yes.
Your Honor, he said that the most he could afford would be $800 right now. Doesn't have any, he's not on probation, doesn't have any other cases pending, doesn't have any felony priors. Could live in Lauderhill if he was released. He spent all his life in Florida, Your Honor. Does have family in Florida and also has 2 kids in Florida, so he would have no reason to leave the state, Your Honor.
And Your Honor, it looks like his month of residence in Lauderhill, it says 0 months residence, so I don't know how long he's been living there. I don't believe that he does have, very strong ties to the community based on that specific address.
Count one, $100,000. Count two, $10,000. Count three, $1,000. Pretrial release conditions if he gets out. What did I put in 11? First one, level 1?
Yes, Your Honor.
Same thing.
And for the record, that would be over state's objection to no bond.
All right. Do you have a legal objection?
Your Honor, I would just ask that you could.
Is it within my discretion? I just want to know if there's a legal objection. I ask that once in a while because I keep hearing objections that have no legal basis. I think after a while I don't want to hear them anymore. Nothing personal. Because I hear prosecutors don't like what the judge says, so they say I object. But do you have a legal objection?
Just that you could find proof evident presumption great if Your Honor felt inclined to do so.
All right, I disagree. I don't believe that I can. And I want that on the record, that I do not believe that on paper alone I can find someone to a virtual certainty guilty of a crime.
Thank you, Your Honor.
Okay.
This is
Frankie Glenn.
Your Honor, this is the other co-defendant in the case as well.
This is
Me
Frankie
and Your Honor.
Glenn. Anybody have anything to say?
Your Honor.
Otherwise, I'm going to give him the same thing.
And Your Honor, I would just, same objections as
Same
before.
objection, okay. 100,000.
Your Honor, if I
one.
may.
I'm sorry?
If I can give some background on Mr. Glenn.
Yes.
He can only afford $500, Your Honor. No probation, no other cases pending, no felony priors. He could live with his parents if released. He spent all his life in Florida. He is gainfully employed currently, Your Honor. All of his family is in South Florida, and he also has a child in South Florida, so he would have no reason to leave South Florida and return to court if he was released, Your Honor.
Well, I don't know if that's correct. I don't know. But, $100,000 in count one, $10,000 in count two, $1,000 in count three, pretrial release, level 1.
And Your Honor, could I just ask if pretrial has any history for this individual?
No priors, Your Honor.
Terrible.
Thank you, Your Honor.
Thank you. Gustavo Recalde.
Needs a Spanish interpreter, Your Honor. And ma'am, if you wouldn't mind speaking loud, it was tough to hear you before.
Sure.
Thank you.
Okay. Reviewed PCF data, find there was a factual basis.
Declaro que hay motivo fundado para los alegatos.
Count one's 1,000.
Cargo 1 es $1,000 de fianza.
Count two's 100.
Cargo 2, $100.
And Your Honor, based on the facts of the case, the state would ask for a $5,000 bond on count 1, for the record.
El Estado pide $5,000 para el cargo 1.
No. Count three.
Your Honor, if I can give some information on Mr. Ricaldi.
Go ahead.
He can only afford a $200 bond, Your Honor. Not on probation, no other cases pending, no felony priors. He's spent the last 3 years in Florida, is gainfully employed, and does have family in South Florida, Your Honor.
Okay, state anything in counts 3 and 4 you want to recommend?
Your Honor, the state would ask for a $10,000 bond on count 3 and $10,000 bond on count 4.
El Estado pide una fianza de $10,000 para el cargo 3 y $10,000 para el cargo 4.
Defense? Okay.
Your Honor, we'd be respectfully asking a $2,000 bond on each count.
Pedimos una fianza de $2,000 según la defensa para cada cargo.
All right. On each of those counts, $7,500 each one.
Para cada uno de los otros dos cargos son $7,500 de fianza para cada uno de los dos últimos cargos.
If he gets out, no contact in any way, manner, shape, or form with the alleged victim in this matter.
Si sale de la cárcel no puede tener contacto de ningún tipo con la supuesta víctima.
Thank you.
Gracias.
Yes.
Edgar Garcia Botero.
Main, Your Honor.
Violation of probation on a felony, no bond hold. Thank you. Russell Newman.
Main.
Violation of probation on a felony, no bond hold. Thank you. Wesley Helms.
Main, Your Honor.
Petty theft, second degree, third subsequent offense. Let me look at this quickly. Any recommendations?
Your Honor, it's a felony. Over bond,
It's a second degree.
It's a-
Second degree felony?
third-degree felony.
It says petty theft, second degree, third subsequent offense. Oh, so it's the third second degree, okay.
Mm-hmm.
Third second degree misdemeanor, which makes it a felony.
Yes, Your Honor, and the state would just ask that the $750 bond remain the same.
$750 bond. Anybody have anything to say on this?
Yes, Your Honor. He can only afford $200. No probation currently, no other cases pending. He's been in Florida all his life. He is gainfully employed. All his family is in Florida, and he does have 5 kids all in Florida, Your Honor, so no reason to leave. He could live with his sister if he was released as well in the area, Your Honor.
What's his history in the last 3 years?
Sorry, just one moment, please, Your Honor. His history must be from another county, Your Honor, because I'm not seeing anything in Broward.
Okay, I'll lower the bond to $500.
Thank you, Your Honor.
Jermaine Black.
Bonded, Your Honor.
Do I sign this?
Yes.
You write bonded already on there?
I'll write it.
Eslin Martinez.
Maine, Your Honor.
This looks familiar.
Yeah.
I believe it's the co-defendant to the.
Oh, to the juvenile case?
It sounds, I don't know.
The issue is burglary.
Right, it's the same thing with the car and the car alarm.
Yeah.
didn't-
That's what I thought
Yeah,
it
I
was
believe it
familiar.
is the same.
Oh, I didn't know they were co-defendants.
All right, I find probable cause.
Okay, Your Honor, defense would be objecting to the probable cause in count 1, as defense counsel did say earlier, where in the police report, it does allude to an attempt, and it does say that he was thwarted by the car alarm. And as Your Honor did find earlier in the same situation, when they were, when they did run away, when the car alarm went off, you did find probable cause for an attempt and not for burglary. So
Oh,
defense-
that's true, that's true. I apologize. Thank you for reminding me.
Thank you, Your Honor.
And I believe in that case, Your Honor, you did find PC for the attempt?
Yes.
Okay. Huh? Juvenile. I don't know if these are because there's co-defendants in.
I don't know, it's just very similar facts. I don't know if,
yeah.
I can't say for sure that they are co-defendants,
I don't
for the
think they
record.
are related.
Okay.
I don't remember the bond I posted on the other. I don't know the facts behind it. Anybody know?
I don't know that a
Your Honor,
bond
if I
was
may-
set because of.
Go ahead, sir.
Thank you, Your Honor. Currently, there is no bond that Mr. Martinez, that he can post, Your Honor. The only priors that he has are juvenile priors. He's been in Florida all his life. He currently is a student, and his family does live in South Florida, so all his ties are to the South Florida community, Your Honor.
No history, is that correct?
I don't see any history, Your Honor.
He's on juvenile probation. Thank you. Any recommendation from the state?
Your Honor, the state would ask for 5,000 on count one, and
I agree. 5,000 count one, 250 on $250 on count two.
Thank you, Your Honor.
And Your Honor, is the state being given 48 hours to perfect, or is Your Honor just finding probable cause to attempt?
What did I do on the other one?
found PC to attempt.
I didn't give you any time to perfect.
No, Your Honor.
Your Honor,
that's fine.
Your Honor, given the circumstances that were given to Your Honor, would you be willing to lower it to a $2,000 bond?
You thought he was on probation. I had no probation, and I just learned that he was on probation, or he is on probation. So that seems to be in conflict with your information, so I'm leaving it the way it is.
Thank you, Your Honor.
Travis Brooks.
Maine, Your Honor.
Am I missing something? Where's the open container?
That might not be included. That's an infraction, so I don't know that they would include that on the probable cause, or if that would have been issued like in a citation.
Well, if I'm finding probable cause, I'm not finding it on that. All right, it's the counts 1 and 3. No, it says not for magistrate. Does that mean
Right, because it's an infraction.
So, well, all right. I'm just saying on the record that based on the PC affidavit, I don't see any basis for the open container, but I don't know if I have any say over that. Being a traffic infraction. It's not even a traffic infraction. I don't know what it is. It's so minor. But as to count 1, I find that probable cause, $750 bond, RR in the other 2 counts. Thank you. Exner Dumal.
Bonded, Your Honor.
Christopher Louisant.
Maine.
How do you pronounce your last name?
Lucent.
Lucent?
So, yeah.
I reviewed the PCF data, find there's a factual basis. State, any recommendation?
State would ask for a $10,000 bond.
Do you have any history?
He does not from Broward County, Your Honor. However, his address is only showing 2 months at this current address, so I'd ask if pretrial sees any other prior history.
All right, defense?
Yes, Your Honor. We'd be asking for a $1,000 bond, Your Honor. He is not on probation currently. No other cases pending. No felony priors. Could live with his wife in in South Florida here. Is gainfully employed, Your Honor, and his family is in South Florida, so he does have ties to the community and no reason to leave.
Where's he employed? Not at this job.
Security.
He does security, Your Honor.
Really? $2,500 is the bond.
Thank you, Your Honor.
Security. Philman Mowat.
Maine, Your Honor.
I reviewed the probable cause affidavit. I find there's a factual basis. $750. And a stolen tag, suspended license, covering up the tag, and state.
State would ask that the bond remain at $750.
Really? Okay, bond $750. Thank you.
Your Honor, Mr. Moa would wonder if Your Honor would be willing to release him on any sort of pretrial release. He does
frankly, I was considering raising the bond, but I didn't raise it, so I wouldn't go anywhere with that.
Thank you, Your Honor.
Trial release is not going to happen. James Major. I reviewed the PCF data, find there's a factual basis.
Your Honor, if I may?
Yes.
I'd like to make an objection to the finding of probable cause in accordance to count 2. It doesn't state a weight, it just says, if I may quote, also greater than what is commonly used for personal consumption, and it also does not refer to how many pieces were found, it just says numerous. So I would argue numerous could mean a multitude of things. They also could have included the weight in here, so I would argue against probable cause in accordance with count 2.
And Your Honor, I don't think that it's necessary to put the weight in there. It says that he was in possession of the substance. The substance was field tested positive to be crack cocaine. I can look up the statute, but I do not believe that that is a requirement.
All right, thank you. I still find probable cause, my ruling stands. Count 1's 1,000, count 2's 2,500, count 3's 100. Thank you.
Your Honor, would you be willing to lower the bond? All that Mr. Major can afford would be $250.
What's his history in the last few years?
Would you like some background, Your Honor?
Your Honor, I am looking, I only see a prior arrest, I do not see any prior convictions.
Your Honor, he has spent all of his life in Florida. He is gainfully employed. All of his family is also in South Florida. And he could live with his mother if released. So we'd be asking that Your Honor would lower to $500 on count 1, $1,500 on count 2.
Okay.
Thank you, Your Honor.
And I'm sorry, Your Honor, what was the bond going to be?
500 on count 1, 1,500 on count 2, and 100 on count 3. It's getting very close here. Carlos Jimenez. Read the PC affidavit, found on a factual basis. To all counts. What's his history?
I don't see any history in Broward, Your Honor. It looks like he just moved here, though. I don't know if he has history outside of Broward.
Can we check on that?
No other priors, Your Honor.
Nothing else?
No, sir.
No history that we know of. What are you looking for in terms of a bond?
The state would be asking for $5,000 on counts 1 and 2. The bonds for the misdemeanors to remain as is in $2,500 on count 5.
Defense?
Yes, Your Honor. We'd be asking for $1,000 on each count. As Your Honor heard, he does not have any priors. He could live with his mother-in-law if released. He's been in Florida for 26 years. He is gainfully employed, and all of his family lives in South Florida, so he would have no reason to live, or no reason to leave. Plenty of reason to live, though.
On count 1, the bond is $2,500. On count 2, it's $1,000. Count 3, $25. Count 4, $100. And count 5, the threat, $1,500. Thank you.
I'm sorry, your counts 1 and 2 were?
Different. One involved the spitting, and one involved an actual battle.
Okay, so I'm sorry, could you just repeat the bond?
500 on count 1, 1,000 on count 2.
And on count 5, I'm sorry?
The last one was 1,500.
Okay.
That was I'm going to kill you and your family.
Right.
Your Honor, we'd be requesting that photos be taken of the defendant's injuries.
Yes?
And so if Your Honor would sign an order allowing that, we'd also ask that Your Honor sign an order allowing the defendant to go into his phone to retrieve phone numbers so that he can contact people to bond him out.
Yes?
Thank you, Your Honor.
Brian Kelly? Two felony violations of probation or community control, each one with a no bond hold. Thank you.
Your Honor, again, we'd just be asking that Your Honor allow him to enter his phone to grab phone numbers to contact people.
Heard the order.
Thank you, Your Honor.
Oh, there he is. Juvans Alcius. And what did you do with this? You perfected it?
Yes, Your Honor, I believe last time this case was here,
I was here when it happened, I made the objection, it was
Sure.
the drug top field testing. And I believe that there is no objection anymore.
No. So the bond account 1's 1,000 and the bond account 2's 7,500. Correct? That's everybody's understanding?
yes, do you have the PC for that one?
Defense?
You gave it to me.
Or the original booking sheet,
I'm
I
asking you a
guess.
question. Are you both in agreement with 7,500 on count 2? Excuse me, count 3. I don't know what count 1 is. And 1,000 on count 2, and I don't know what number 1 is.
Your Honor, we'd be asking for a lower bond than that. We'd be asking for 500 on count 1 and 4,000 on count 2 and 4,000 on count 3. The defendant has spent the last 12 years here. He is gainfully employed, has family and children in South Florida, would live with his girlfriend if released, and also his son has a championship game tomorrow that he would like to get to, and he would not be able to afford the bond that is currently available to him.
I would ask that you keep the bond as you had previously stated.
History?
I don't have a booking sheet for him, Your Honor. Let me look quickly to see if I can find. Your
Are we
Honor,
looking
he
for
does
count one?
currently have a pending dealing in stolen property pending in front of Judge
No.
Yusan.
Okay, the bond stays as it is. Thank you.
And I'm sorry, Your Honor, do you mind saying that just one more time for the record? I didn't catch it. It was
1,000 on
75.
count one and 7,500 on count two.
Okay.
Folks, I believe that's it.
Your Honor, I believe we have two matters I need to address. The first one, sorry, do you want the case number? Would be Jeffrey Cray. It was on Your Honor's docket yesterday. I believe I was informed Your Honor set a bond for the failure for the seatbelt at $250, which is a I believe Your Honor is not able to set a bond on this. So we need to.
I'm not?
As it's an infraction.
What? Okay.
And so,
You can read it. I don't know that's I wrote it. You have the two orders on the side of the front page.
I have to address one more matter, but yes, I do have those. One more matter, sorry. Is it failure of the safety belt? These are these two orders, let me see.
That's fine.
Thank you.
But I do need to address one matter that's not on the docket.
I'm wondering why. Oh, yeah.
Thank you. Your Honor, if I may?
Yes?
Okay, this is in regards to Sean Charlton. I did address this matter on Friday in front of Judge Lee. My supervisor had asked me to address it, and she didn't give me. Judge Lee was hesitant to change something because this deals with Judge Miller's case. However, per speaking to my supervisor, she has instructed me that Judge Miller has. That she has met with Judge Miller in accordance to, I guess this has happened a couple of times, and Judge Miller has agreed that it is okay to ROR the clients in these instances. My supervisor said she.
What is this? What are we talking about?
Basically, so what happened is Mr. Charlton resolved a case for petty theft where he was supposed to do community service, and he subsequently did not do all the community service. And so what happened was Judge Miller had set a date for him to come in about a hearing about not completing the service hours, and he subsequently didn't come. So we had an active KPS, and this is happening in a couple of Judge Miller's cases where people are just being held on KPSs for community service hours. And so Judge Miller, now being made aware of this in January, has agreed and said that it is okay to ROR these clients because this guy, Mr. Charlton, has now been in custody for, I believe, 8 days on a KPS for a closed case. And my supervisor said she will go on the record and
It's going to be closed if he's doing community service hours.
Well, I believe.
Technically, they put out judge, but the judge orders the community service, and I guess he gives them a certain amount of time to come back with the community service hours. If they don't comply with that, then he issues a case. But the case itself
Well,
is closed.
you don't need an appellate court to tell you that's illegal.
And Your Honor, and so
Maybe you tell me, there's a judge out there that sentences you, then tells you to do, not part of the sentence, but tells you you gotta do 50 hours of community service?
Frame to do it, like he'll take a plea, withhold court costs, community service 30 hours, takes a plea. If they don't come back within a set time that he says the community service needs to be completed, then he issues a case.
Oh, that's a little different.
Yeah.
However, like I said, Judge Miller is aware that this has been happening now because what happens is he's now subsequently being held with no next court date because no violation of probation is filed. He doesn't have a status hearing or anything.
He wasn't put on probation.
Exactly, and so that's why this situation keeps happening where now people are subsequently being held with no future court date because there's no status, there's no violation, there's no next proceeding, the case is closed.
So, are we on the record?
Yes, Your Honor, and like I said, my supervisor is
So
willing.
the judge did not say, non-reporting probation, 50 hours community service within 6 months.
No, Your Honor.
Because if he had said that, there'd be no problem.
No, Your Honor.
Well, yes, Your Honor.
I'm sorry. Yes, Your Honor. And as I said, my supervisor is willing to go on the record on the phone, appear by phone. She has met with Judge Miller because Judge Miller has subsequently been informed of this, and there is a state attorney that was present at the meeting too. And Judge
What do you
Miller
want from me?
to agree to ROR, Mr. Charlton.
Judge Miller has agreed to that?
Yes, Your Honor.
You had Judge Miller's phone number?
I do not, Your Honor. I could call my supervisor, who probably would have it, and she will be able to testify on the record that she has met with Judge Miller, and Judge Miller has
I
agreed to
can't do
this.
that over the phone. I'll talk to the judge over the phone, if you can get that number.
Does Madam Clerk have Judge?
I don't even know who Judge Miller is.
He's out in the satellite, Judge.
If you want to give me a moment, Your Honor, I can look it up.
No, you won't have his home number.
I will have. I understand, but if Your
But I
Honor
can
could
get
at
that
least.
from Sheriff's Office. I don't know who to call though.
We set it for tomorrow to,
Communications.
I mean, it's not. That's the thing is there is no future court date. What is it reset for tomorrow on? It's
I
not
mean,
on
that
the
way we could
docket.
get the judge, we could speak to the judge, because she's not gonna, I mean, you would at least have her JA's assistant, and would be on business day, and you
Well,
could call her.
I would appreciate if Your Honor would allow me to have time to call her at least today, because like I said, Mr. Charlton has
Yeah,
subsequently
the
been.
person's in jail?
Yes, Your Honor, and he's been in jail for over a week now, and Judge Miller is aware of this and has agreed that it is okay in case.
I got
I understand.
it. I got it.
I'm just saying, would Your Honor
The
allow me?
record's clear.
Would Your Honor allow me time to call her or attempt to call Judge Miller?
What's the number for communications?
Because they're ad charges. So Carlos Jimenez?
Well, for whoever communicates. They're the ones that'll give me his private number. Is Miller a man or a woman?
Judge Terry Miller, Your Honor, she's a
What?
woman. A woman. Judge Terry Miller.
That's a
Terry,
woman?
Terry,
That's
she's
a woman?
Yes, she is in the South Satellite.
Carrie Miller.
Terri, Terry, I believe.
Terry. Well,
Yes.
okay. T. I thought you said Carrie.
Sorry.
Do you have the number for communications? No, I'm gonna call on this line. I wanna call on this line here.
You know what number to call?
No, that's what I'm asking. Who do I? No, that's not communications. That's the open line for the public.
Communication, right?
What's the name of the defendant?
Sean Charlton, Your Honor. Your Honor, like a
Judge
case.
will know that by that name?
No, but the judge will be aware of the situation because this has happened a couple of times now.
Carlton?
Charlton, Charlton.
Arrest number or case number for
What?
this case?
Can you ask the state, please? I don't.
I don't.
Shh. Come on.
Oh, sorry.
954
Don't you have access to the computer?
764
Can you tell me how to spell his last name?
No, it's for this.
4730.
I'm sorry, Brooke was writing the
Wait,
Thank
Carlos
you.
Jimenez, that's fine.
And folks, want to get out of here.
case number.
Oh, for Jimenez, sorry.
I gotta move out of my office.
Here you go. Sorry, I didn't know what you were asking for. I thought it was on this case, so I was confused.
No answer.
And that's the main courthouse over there at Gage.
I'm not getting an answer. You said 954-764-4730. All right, that's not working. It says unknown on here, so that's. It should be 4 digits.
Can you add the case number for me, please?
Let me turn these things off. System.